the Honorable the President.
Let us pray. Almighty God, we willingly acknowledge you as the supreme being, most gracious and most merciful. Look down, we beseech you, on us who are members of this Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth and help us to accept it with all its implications into our lives. Direct us, O Lord, in our deliberations, so that setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in this Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen.
Oath or affirmation, announcements by the President, bills brought from the House of Representatives, petitions, papers.
Minister in the Ministry of Finance.
Thank you, Madam President. Madam President, I have the honor to lay on the table the following papers as listed on the order paper in the name of the Minister of Finance. The report on the operations of the National Insurance Board of Trinidad and Tobago for the financial year ended June 30, 2018. The special purpose audited financial statements of the National Insurance Board of Trinidad and Tobago for the financial year ended June 30, 2018, and the Financial Amendment Regulations 2018. Thank you, Madam President.
Reports from committees.
Senator Mark.
Thank you. Madam President, I have the honor to present the following as listed. Following report, rather, as listed on the order paper in my name. The 12th report of the Public Administration and Appropriations Committee, 3rd session, 2017-2018, 11th Parliament, on the examination into the administration of disaster relief in Trinidad and Tobago.
Mr. Vice President.
Madam President, I have the honor to present the following report as listed on the order paper in my name. The interim report of the Joint Select Committee appointed to consider and report on the Constitution Amendment Tobago Self-Government Bill 2018 in the 4th session of the 11th Parliament.
Minister in the Ministry of Finance.
Madam President, I have the honor to present the following report as listed on the order paper in my name. The interim report of the Joint Select Committee appointed to consider and report on the Trinidad and Tobago Revenue Authority Bill 2018 in the 4th session of the 11th Parliament. Thank you, Madam President.
Urgent questions, questions on notice, questions for all answer.
Leader of Government Business.
Thank you very much, Madam President. Madam President, the government is pleased to announce that it will be answering question number 35, number 71, and number 72. We ask for a 2-week deferral of questions 36, 37, and 73.
Questions number 36, 37, and 73 are deferred for 2 weeks. Senator Mark.
Question number 35 to the Minister of Energy and Energy Industries.
Minister of Energy and Energy Industries.
Thank you very much, Madam President. Madam President, as a consequence of higher gas prices contracted with the upstream oil and gas companies, the gas prices negotiated by the NGC with the downstream companies have been higher. However, a number of downstream companies have already signed new gas sales, gas purchase agreements based on a new gas price. At this time, there is no indication that these higher prices will lead to a loss of jobs or to shut down of plants at the Point Lisas industrial estate.
Yeah, Madam President, can the Honourable Minister indicate how many contracts with the NGC have been signed by these downstream producers? Did they indicate?
Minister.
To date, the NGC has signed new contracts with CNC, with Nutrien. Nutrien is by far the largest ammonia producer at Point Lisas. CNC is also a large ammonia and methanol producer. CNC, Nutrien, and N2000 it has also signed contracts with PLNL, Point Lisas Nitrogen Limited.
Senator Ma.
Madam President, through you, can the Minister indicate how many outstanding contracts with downstream producers are still to be signed?
Minister.
I'm not sure the exact amount, but the only one of the big players still to be signed is MHTL, and they are currently in negotiations. But everything seems to be pointing that settlement will be arrived at shortly.
Senator Ma.
Madam President, can the Honourable Minister indicate to us what role, if any, did the Prime Minister have to play in these negotiations for new gas prices along with NGC?
No, Senator Mark, that question does not arise.
Madam President, can I?
You have one more.
Yeah.
Yes.
Can I ask the Honourable Minister if he can share with us any information as it relates to the new gas prices for producers in the downstream sector?
Minister.
Madam President, Senator Mark knows the answer to that. But I will still repeat it. There are confidentiality clause on these commercial gas prices arrangement, which forbid us to disclose the actual price in which the gas is sold and or bought.
Next question, Senator Mark.
I think you postponed two for me.
Oh, I apologize. Senator Obika.
Thank you very much, Madam President. Question number 71 to the Minister of Tourism.
Minister of Tourism.
Thank you very much, Madam President. Madam President, PNM administrations, including this one, have a proven track record and a legacy of investing in our citizens through education and training to ensure equal opportunities for all, as well as alignment with the workforce needs. Government has long provided subsidized tertiary education through GATE, which was established under PNM administration. And Trinidad and Tobago boasts of having several educational institutions dedicated to providing hospitality and tourism training to specifically meet the needs of the sector. These include the Trinidad and Tobago Hospitality and Tourism Institute, which offers and provides a number of programs ranging from short courses and certificate programs to associate degree and Bachelor of Science programs such as a Bachelor of Science degree in Culinary Management, associate degrees in Culinary Management, Food and Beverage Management, Hospitality Management, Tourism Management, and Sport Tourism Management. Industry-specific training which meets the operational needs of the sector, including food and beverage service, quality customer service, tourism awareness, tour guiding, supervisory skills, and housekeeping. The Tobago Hospitality and Tourism Institute offers both short courses and associate degree programs in tourism studies, culinary arts, food and beverage operations, and hospitality studies. COSTAT offers a certificate in tour guiding, which is widely accepted in particular by the Trinidad and Tobago Tour Guides Association. In addition, the University of the West Indies offers a Bachelor of Science degree in International Tourism Management, a postgraduate diploma and a Master of Science in Tourism Development and Management. And the University of the Southern Caribbean, a private tertiary level institution, offers Bachelor of Business Administration in Hospitality and Tourism Management. There are plans to offer a certificate program in 2019. It should be noted that in addition to the specific institutions and programs which I have just highlighted, the tourism sector employs persons drawn from a wide range of disciplines and training, including marketing, management, languages, communications, and other technical areas. Therefore, in light of what is presently offered, there are no plans to increase the offerings of the educational institutions at this time.
Senator Obika.
Thank you very much, Madam President. I thank the Honourable Minister for the submission. I wish to ask how many students in quantum have accessed the courses at the institutions in general that he's referenced.
Minister.
Yeah, I do not have these specific figures, but over the past few years, I know a figure of 1,500 persons who would have passed out of these programs, but I don't have it specifically.
Senator Obika.
Thank you. Couldn't the Honourable Minister indicate if all these institutions are GATE approved and have been receiving GATE funding to this fiscal year?
Minister.
Many of the programs are GATE approved, but I don't know which programs. I know the associate degree and the Bachelor of Science degrees are GATE approved, Madam Speaker, but I can't tell for all because there are many other programs being offered.
Senator Obika.
And then could the Honourable Minister indicate, even though it's not under his ministry directly, why TTHDI has not been receiving GATE funding as of this fiscal year and the
No,
last?
that question does not arise.
Could I then restate a different, last supplemental?
You have one more question you can ask.
Could the Honourable Minister, in light of the scenario painted, explain why TTHDI has resulted in they have declined the student enrollment by hundreds? The figure I have received is 500 less students being enrolled. Could the Minister reconcile that?
Madam Speaker, TTHDI is under the Ministry of Education, so I can't answer to that.
Next question, Senator Obika.
Thank you very much, Madam President. Question number 72 to the Minister of Foreign and CARICOM Affairs.
Minister of Foreign and CARICOM Affairs.
Thank you, Madam President. A High Commissioner has been fully accredited to the Federal Republic of Nigeria. The High Commissioner now serves as Head of Mission of Trinidad and Tobago's High Commission based in Abuja, Nigeria. Relative to the second part of the question, Madam President, I'm pleased to further advise that the High Commissioner presented his letters of credence to His Excellency Muhammadu Buhari, President of the Federal Republic of Nigeria, on September 13th of this year, 2018. Madam President, I thank you.
Senator Obika.
Thank you very much, Madam President. I thank the Honourable Minister for the submission. We'll be grateful for that information. The question I have is, given that the Ugandan mission was collapsed into Nigeria, can the Honourable Minister indicate if the High Commissioner at Abuja has been able to be accredited in East Africa?
Minister.
Thank you, Madam President. The countries and organizations which were accredited to the High Commission in Uganda are now covered by the High Commission in Nigeria. Relative to the countries of Uganda, Kenya, Tanzania, and the African Union, the High Commission in Uganda was also accredited to Egypt and Saudi Arabia, but these countries were not reassigned to an existing mission when the High Commission in Uganda was closed. Thank you, Madam President.
Senator Obika.
Thank you very much, Madam President. Could I then ask pointedly if our Excellency at Abuja has been able to present his credentials to the President of Uganda?
No, that question does not arise. Any other supplementary?
Could the Honourable Minister indicate any reason as to why it took the government 3 years to get the accreditation sorted at
That question
Abuja?
does not arise. Any other questions? Okay.
Could the Honourable Minister indicate what fallout took place arising from this inordinate time to be accredited?
Senator Obika, you're in that, you're not even asking a question, you're presuming certain facts, and I will not allow that question either.
Motions relating to the business or sittings of the Senate and moved by a minister.
Honourable Senators, I will seek your leave to revert to this item later in the proceedings. There is some housekeeping to be done with respect to this item.
Public business, government business, bills second reading.
Attorney General.
Thank you, Madam President. Madam President, I beg to move that a bill entitled An Act to Amend the Proceeds of Crime Act, Chapter 1127, the Anti-Terrorism Act, Chapter 1207, and the Finance Intelligence Unit of Trinidad and Tobago Act, Chapter 7201, be now read a second time. Madam President, it seems as if we were here just not a minute ago. I am very pleased to be back in the Senate to spend time with honorable members of this chamber in facilitating the business of the people of Trinidad and Tobago. Madam President, the bill before us appears to be simple. It is just a few pages long. It's exactly 4 clauses long. The first clause is the short title. The second clause treats with amendments proposed to the Proceeds of Crime Act. The third clause proposes amendments to the Anti-Terrorism Act, and the fourth clause proposes amendments to the Finance Intelligence Unit Act. Permit me to give a little bit of background and framework, in particular to people who may not be familiar with the articulation of these laws and the origin of the obligations that these laws require from time to time to be improved. Trinidad and Tobago is a member of the international community, very importantly, in the United Nations. We joined the United Nations a very long time ago. We signed on to their conventions, and we were required specifically to treat with our obligations under the United Nations Security Council resolutions in particular. The UNSCR regulations that really bite into the business of Trinidad and Tobago's obligations are UNSCR 1267, which was our obligation in 1999, UNSCR 1989, which came about in 2011, UNSCR 2253, which came about in 2015, UNSCR 2368, which came about in 2017, UNSCR 1988, which is of 2011 vintage, UNSCR 1373, which is of 2001 vintage. Now, the one thing that we know, Madam President, is that the international community and Trinidad and Tobago share a similar passion. The international community, in organizing itself, tends to take the very best and even the most esoteric, and then again, even the most basic human obligations into a neat perspective. The United Nations has said to the world, and Trinidad and Tobago as a member of that, subscribes and ascribes to the principles that we must stamp out the scourge of terrorism. We must frown upon and limit and completely block, as best as we can, the financing of terrorism. We must ensure that corruption and money laundering and the proceeds of crime are managed to the disadvantage of those that commit crime. And in those basic obligations, Trinidad and Tobago finds itself in the position where, beginning in the year 2000, then in the year 2005, then in the year 2009, we made some revolutionary improvements to our laws. Firstly, we made sure that we brought about our Proceeds of Crime Act, our Anti-Terrorism Act, and our Financial Intelligence Unit Act. The Proceeds of Crime Act is Act number 55 of the year 2000. The Anti-Terrorism Act is an Act of Parliament number 26 of the year 2005. The Financial Intelligence Unit Act is Act number 11 of 2009. Those 3 pieces of law coordinate with a subsidiary piece of legislation called the Financial Obligation Regulations, which come about as subsidiary laws under the Proceeds of Crime Act. Those 4 pieces of law, 3 primary, 1 subsidiary, are what comply with our standards for international regulation and international supervision. The 4 entities that operate these laws are primarily found, firstly, in the central bank as a major supervisor of elements. They're to be found in the Director of Public Prosecutions, in the work that is set out for the DPP in the Proceeds of Crime Act. They are to be found in the Office of the Attorney General, Minister of National Security, and Minister of Finance as to one part of the Anti-Terrorism Act, and also the DPP as to another part of that. and then they are to be found in the mixed basket of regulations where we have entities that coordinate alongside with other regulation entities. I mean specifically the SEC, the Stock Exchange. Those entities work alongside with the Supervisor of Insurances, the Central Bank, etc. So we've got this matrix of laws that work together. We have this understanding of positions. And what we have now is our international obligation coinciding with our local obligation. I'm literally finding it hard to find a focal point in the Senate today because everybody seems so busy. I feel as if I'm talking to myself, quite frankly. But let me proceed. I'm searching for one face, and I mean that genuinely. So it's important, Madam President, to understand what we are doing from an international and local perspective. In the international environment, we have two major regulators. We have the Financial Action Task Force, and we have the Global Forum. In the Financial Action Task Force methodology, the Caribbean Financial Action Task Force is something called an FSRB, a FATF-style regional body, which asks you to go and regulate your pot of countries. In Trinidad and Tobago's case, we are a member of 25 countries in the Caribbean Financial Action Task Force. In the Financial Action Task Force, we're obliged to look at 40 recommendations and 11 immediate outcomes. Those recommendations and immediate outcomes are assessed against two categories. One, your technical compliance. Do you have a law to treat with the thing that they're asking you to treat with? And secondly, your effectiveness. Are your laws being applied, and do you have any results to show for it? That's FATF world. The Global Forum world is more pointed. It treats with our obligations for taxation and tax transparency. It treats with our making sure that we don't have favored tax regimes in how we balance special economic zones or trade zones, etc. And we deal with reciprocity of income tax relief from bilateral arrangements or multilateral arrangements. So that's the global environment there. On the local arrangement, this government's focus in the battle against crime is largely centered around improvements to our systems to ensure that you can follow the money. The following the money required institutional improvements, and it also required tweaking with our laws. On the institutional improvement side, they include improvements to the criminal justice system to make sure that your cases actually get to court, they can be tried in court. You have rules of court, you have courts, you have judges, you have defense attorneys, you have a computerized environment. Your files move with alacrity, as they currently don't, between the magistracy and the High Court or the DPP's office and the respective domains where you are actually doing the filings pursuant to orders of the court. When we come now to the international obligations before us, let me state, the international obligations are constantly moving. Trinidad and Tobago and the FATF underwent 4 mutual evaluations. Groups of experts came to our country on 4 successive occasions, looked at us in first round evaluation, second round evaluation. Then they looked at us in third round evaluation. We were not quite complete with third round evaluation. They said, roll up your third round evaluation and go into your fourth round evaluation at the same time. Now, Trinidad and Tobago was put into this cycle by way of a commitment of the government of Trinidad and Tobago sitting then in January 2015. In 2014, the then government said to Trinidad and Tobago, we will be the first country amongst countries of the world to undergo fourth round mutual evaluation. And the fourth round mutual evaluation is really a very big ticket item. Because after your fourth round mutual evaluation, that's when the dance is serious. So committed to fourth round evaluation, not having finished our third round evaluation, the experts came to Trinidad and Tobago in January 2015 and they assessed us against the 40 recommendations and 11 immediate outcomes. And basically speaking, we didn't do well. The level of not doing well required us to go into 2 forms of supervision. We went into the Financial Action Task Force cycle of review. It's under a body called the International Cooperation Review Group, the ICRG. In that ICRG, they treat with you in 2 ways depending upon your size. If your GDP is over $5 billion US, you are treated individually. Your country is named individually. If you are less than $5 billion US, you fall into a pool, so you're not really named or singled out for treatment. Trinidad and Tobago, being above $5 billion US in GDP, find ourselves being named in the publications of the Financial Action Task Force. The Financial Action Task Force sits 3 times a year, and in that, they set to you the requirement that you give your high-level commitment, political commitment, in which case I have done that. They ask you to develop an action plan for items. You're not permitted to publish that action plan because it's a confidential arrangement with the assessors. That action plan requires that you agree to achieve certain targets by certain timelines. This Senate will remember well on a previous bill that we indicated that November 30th was a deadline date for us to treat with the income tax amendment bill because we needed to tell the FATF that we had done certain things. We in fact did that by way of passage in this House, and on the same day, November 30th, we reported that we wanted to seek re-ratings to improve our status in 22 of the recommendations. Now that's a big haul. Having given our recommendations, we are required on January the 4th to undergo a mutual evaluation, joint group sort of approach, where the assessors come to Trinidad and say, okay, you are required to make progress because you're not allowed to just sit still and do nothing. You must achieve compliance in progressive steps. And on the 4th of January, we're going to have to report as to what we have done against our milestones. The Income Tax Amendment Act is now part of that, and these matters before us here today are part of that. And I'll explain them when I get to the context of the clauses themselves. So on the 4th of January, we have to do this assessment, which is why we warned that we would be sitting again in respect of this bill. And so, very graciously, the Senate has made no complaint in working back to back, and I wish to thank honorable senators sincerely. I know you have busy lives and busy practices. This time of year is also one which is occupied in doing a lot of charitable work, etc. And I really do wish to thank the honorable senators for making themselves available so graciously. And very importantly, I thank the staff of the Parliament and the Hansard in particular for the human service that they continue to do, Madam President, in making sure that our work is as efficient as it is. I invite every senator to take a trip up to the administrative floors in this Parliament and go and meet the people that really run our business, in particular the Hansard members. Madam Speaker, Madam President, the international obligations that center upon us today now across these 3 substantive clauses are as follows. First of all, Clause 2 amends the Proceeds of Crime Act. Now, I genuinely recommend to all senators who are not lawyers, if you have not read the Proceeds of Crime Act, read it from cover to cover. I apologize immediately that the laws of Trinidad and Tobago are not published in revised form. We have, as a cabinet, taken the massive amount of amendments that we've done in the period 2015 to 2018, and we are in the course of confirming the revised laws of Trinidad and Tobago, which will be published very shortly. But the Proceeds of Crime Act, honorable senators, is a masterpiece that is waiting to be properly implemented in this country. The Proceeds of Crime Act is divided into several parts. Part 1 deals with the confiscation of proceeds of a specified offense. It's largely all the DPP's work. Part 2 deals with money laundering, and Part 3 is miscellaneous provisions, where you set up a seized asset committee. This piece of law has been working, but it hasn't been working fast enough. And this piece of law really required us to do the amendments which we as a Senate have spent a lot of time prior to the change in the Senate bench, the previous independent bench, and now this bench. We've been engaged in the criminal justice reform because this Proceeds of Crime Act sits largely in the criminal arena. Importantly, we've been improving the move away from just pure indictable offenses, which must go through preliminary inquiry until we abolish it shortly. And we've been moving to summary courts. We've been moving to increase the capacity of courts, etc., etc. But the Proceeds of Crime Act is a linchpin in treating with follow the money and in the battle against terrorism. What we propose in this bill is to amend the Proceeds of Crime Act effectively. We're going to firstly amend the definition of financial institutions. Secondly, we are going to amend, so there are basically 10 amendments in the Proceeds of Crime Act, depending upon the way you count it. The first one is where we treat with the definitional aspects of financial institution. Then we treat effectively with an important element called tipping off, and I'll come to that. Then we treat with the removal of certain cross-reference inaccuracies, etc. And we also treat with the penalties, and we deal with something called inchoate offenses, which I'll come to shortly. So Clause 2A amends Section 2, which is the interpretation section of the Proceeds of Crime Act, where in the definition of financial institution, we're deleting the words agent. An agent is being removed in respect of an insurance agent. And the obvious question comes about, well, why do you want to remove an agent? Surely an agent, as a frontline person, can be somebody who can spot a suspicious transaction or suspicious activity. But we're removing the concept of an agent specifically because the cost of money laundering enforcement, the cost of AML, CFT as they call it, anti-money laundering and countering financing of terrorism, for every dollar that you regulate, it costs you about $5 to do it, to regulate it. So it's very expensive. Because insurance is done through a system where the placement or underwriting of insurance is done by the broker or the insurance company itself, we felt it prudent, in keeping with the blessings from the FATF, that we would remove the agent, because the agent is effectively going to be supervised by the inspector under the central bank arrangements and the Insurance Act arrangements, both in the present law and in the law which is soon to be proclaimed, which is the new Insurance Act. We are also proposing that the risk, because the first recommendation one, your risk assessment, that risk assessment having been conducted in Trinidad and Tobago shows that the placement of life insurance policies are not really a risky factor. And the central bank has confirmed and the FATF has blessed that life insurance is a low-risk investment which can be excluded out of this position, again because of the regulatory supervision which the CBTT has in its capacity under the Insurance Act. Clause 2B, Madam President, may I ask what time I must end? Half past?
You end at 29 minutes past.
Thank you, Madam President. Clause 2B amends Section 51 of POCA, Proceeds of Crime Act. Section 51 of the Proceeds of Crime Act is a massively important section. It deals with tipping off. In the tipping off arrangements, presently the law is that if you believe a police officer is dealing with a suspicious activity report or a suspicious transaction report, and if you tell or warn someone or tip them off that the policeman is doing his job, you commit an offense. Now let's explain how the policeman gets there. The Financial Intelligence Unit has people that report to it. Those people come from listed businesses or from supervised entities. The supervised entities are banks, insurance agents, the SEC, whomever it may be. The listed businesses include attorneys at law, real estate agents, jewelers, pawnbrokers, value for money, money transfer services, etc. All of them report suspicious transactions and activities to the FIU. When the FIU does its analysis, it reports it to the Financial Investigation Branch, which is the division of the Trinidad and Tobago Police Service, which deals with it. But tipping off right now in that circumstance where it only gets to the police is limited. And in going for the risk-based approach, it is prudent, and the direct recommendation came in our mutual evaluation report, that we should include the offense of tipping off if you are aware that the supervised entity or the listed business is in the course of considering an STR or SAR. So we're taking it down the ladder to the person. So for instance, an attorney at law sees a suspicious transaction, wants to report the transaction, the clerk in the attorney's office calls up the client and says, hey boy, it looks suspicious, the attorney is about to make a report on you. That is tipping off. So we've taken it a step away from the police and the FIU, and we've put an obligation upon those who operationalize the law to ensure that tipping off is not a feature of warning people about crime. Madam President, We then go, of course, in the tipping off to comply with recommendations 21 and 18. And those recommendations were revised as recently as February of this year. And so we had to do some fine-tuning, which is why this bill has come at this hour. It is not as if we could have done it sooner, but with the moving goalposts from the international assessors, we've only got the information and are only now able to comply with it. Madam President, Clause 2C treats with an amendment to Section 53. This is the penalties. Now, I want to confess right now the obvious. Yes, the Accessories and Abettors Act, Chapter 1002. Yes, the common law. Yes, Section 66 of the Interpretation Act all deal with accessories, aiders, and abettors. That's a given. So if that's a given, why am I asking that we put in Clause 1A into Section 53 of the Poker Act? Because we have hit the traditional roadblock. The assessors come largely from civil law jurisdictions, the European base. They have said to us specifically that they want to be comforted that our law, the Proceeds of Crime Act, treats with what we have argued the law already provides. Section 66 of the Interpretation Act, Aiders and Abettors Act, and the common law all provide that accessories to the offense are to be caught that way. We argued it out. In 2015, January 2015, my predecessor, Attorney General, argued that out, and we failed. So we are engaging in something that is properly superfluous. We are adding something into our law, but insofar as it is superfluous, I don't need to be worried because it just codifies what the existing law is anyway. So that's what Clause 2C does in terms of amendment. We're adding in that a person who knowingly attempts, aids, abets, conspires, procures, otherwise facilitates the commission of an offense under Section 45, and Section 45 is the money laundering section, commits an offense. We're also going a little bit further to deal with a very important subsection, subsection 4 in Section 53. Section 54 of the Proceeds of Crime Act required that the minister with responsibility for public administration should have made regulations to put the state under an obligation to obey the Proceeds of Crime Act. Those regulations were never done, full stop. But it was an easier fix for us to repeal Section 54 and bring into Section 53 a direct obligation that says, notwithstanding 2 and 3, where a person is employed in the service of the state as a public officer or on contract, you commit an offense for tipping off. Summary in the manner that we say, and in Section 52, where you're treating with it as well. Those are the tipping off provisions put in there. So what we have done is we have cured the obligation and the untidiness of having a Minister of Public Administration go off and make subsidiary law, and instead we're putting it into the parent law that public officers, contract officers working for the state are to be obliged to not tip off people. Why? The state is the largest generator of revenue. It is the largest employer. It is the largest recipient of potentially suspicious transactions or suspicious activities. Valuations Division, Stamp Duty, Inland Revenue, Ministry of Finance, Attorney General, all of these agencies, state bodies, all of them have the potential to see money which is improperly utilized, or which it looks or sounds or smells like money laundering, and therefore we make sure that if the state is engaged in an SAR or STR, that we put the obligation upon the public servants to not tip off people. Yes, please.
Madam President, I'm grateful to the Attorney General. Attorney General, thank you for providing the material that the office just provided. But before you move on from the issue of tipping off, I was just looking at the amended version to Section 53. And am I correct in saying that what you propose in Clause 4, the new Section 51 in relation to public officers, that the fine that you propose to be imposed on the public officers is half of what would be imposed on an ordinary person? And before you move on from that point, could you just provide the justification for that particular policy of it being half instead of an ordinary person from a public officer? Thank you very much.
Yes, Senator Ramdeen, and again, I apologize that I only just provided the marked up version of the Consolidated Act. I really should have thought of doing that, but we came quickly. And secondly, yes, Senator Ramdeen, you're correct. It is half, and we have gone for half of the offense because we're taking it in a phased approach. Honorable members will note that the Public Services Association under Watson Duke made significant cry about the level of the offense at half, saying that public servants had a significant climb and that this was something which would be unduly onerous. So we sought to take it in a phased approach, which is why we went for half of the offense at present. So, and the idea and rationale for it is that once we apply it and we look at the indices, that we can then adjust it over time as we go forward. Madam President, I've dealt with clause 2D, which is to repeal section 54 for the reasons of putting it in section 53.4. Clause 2E amends section 53.3, capital C. There was a cross-reference error. It should not have been a reference to 55.3C. Sorry, it should not have been subsection 1. It should have been subsection 2A2, and that came about by way of the observation of the FIU, CBTT, and the SEC in saying that it was an incorrect cross-reference. Clause 2F amends section 55 capital B, which is the exemption from liability. And what we are doing here is we're inserting the following words: whether or not the underlying criminal activity was known or any illegal activity occurred. And this again ties in with the tipping off provision. It was argued in the mutual evaluation report that a smart lawyer could come in and seek to take advantage of the current construction of the law, and what we wanted to do is to improve the level of protection so that we could actually have the position where the underlying criminal activity is treated with regardless of whether the illegal activity occurred or not. So it encourages the fact of reporting. It encourages the suspicious activities. We didn't want to make it such that only if the activity actually occurred, because at the point of suspicion, you don't really know if it's real or not. It's just merely a suspicion. Clause 2G amends section 55 capital D. This is where that specific section in the Act is where you have the power of entry, the supervised authority. Now, under our law, you can only enter with consent. If you don't get consent, you have to go and get a warrant. That's something that the assessors complain about. The assessors are asking this country, we don't do it here, but I'm just letting you know, for us to go and amend the law so that a supervised authority entity can have the automatic power to walk in with or without a warrant. A lawyer's office, a bank, etc. It's something that we have fought against because we believe in our society that the warranting is the proper approach to go for, because it's quite easily obtained. What we do in clause 2G, however, is we're removing the National Insurance Board and the UTC. And the question obviously asks why. The question to be asked is why. And now we're removing the NIB because the NIB's inclusion was superfluous. The FATF told us, we don't actually need you to look at the NIB, the nature of their products and services, their investments, because they're largely investment in orientation. They are not required to be supervised. You're unnecessarily burdening the weight of AML CFT costing, and therefore it's safe for you to remove it. We checked it with them. The UTC is being removed, again, because of the nature of the UTC services, and very importantly, because the UTC is actually supervised by the central bank under the UTC legislation. I believe it is section 32 of the UTC Act itself, which says that the CBTT can cause the UTC to comply with any written law, which obviously includes these laws here. So we were given that recommendation, again on a risk-based approach, that those two entities could be removed, specifically because the UTC, in the nature of their products, is supervised by the SEC. So there's already a regulatory figure there, CBTT and SEC in the UTC legislation. That also fits in with the fact of the definition of a financial institution from FATF, because the FATF does not include those two entities in its definition. Clause 2H amends section 57.2 of the POCA. That treats with offenses and punishment. And what we're looking at is the mutual evaluation report. Again, we're adding a level of protection. The mutual evaluation report told us that we had gone too far. And what we're doing is we're ensuring that we improve the level of protection there. Clause 2I inserts something called the National Anti-Money Laundering and Counter-Financing of Terrorism Committee, NAMLAC. NAMLAC was born in the year 2006 by way of a cabinet minute. NAMLAC was centered into its current version as this law now prescribes by the UNC government in 2011. The cabinet came up with an improved, more expanded version of the NAMLAC. The assessors said to us, you need to put the NAMLAC into law. We agree with that because you'd be improving the systems of governance in this country. So we have put the NAMLAC into law, and we have mirrored the 2011 cabinet note, which is the current structure. Yes, it is true that all of these things are basically executive appointees. Yes, it is true that the minister's representation is there, but that is the current system. It satisfies comparison elsewhere. Barbados, Jamaica, Cayman Islands, they all have the same approach. They are all done the same way, the United States of America, etc. Madam President, if I turn next to the clause 2I, here's where we are giving NAMLAC the ability to govern its own procedure. This is in keeping with elsewhere in the Proceeds of Crime Act, Section 58I, for instance, where the Seized Asset Committee regulates its own procedure, the Environmental Management Act, etc. There are umpteen precedents in law in our local provision, and so we've mirrored that for consistency in terms of architectural set out of the law. Clause 3 treats with amendments to the Anti-Terrorism Act. The Anti-Terrorism Act here, Madam President, what we're effectively doing here is we're putting in a unit called the Anti-Terrorism Unit. Why? The Attorney General has, pursuant to the Constitution, Section 76, the Attorney General has responsibility for the civil law and for the criminal law in certain defined ways. And under the Anti-Terrorism Act, there are three players: the DPP, the Commissioner of Police, and the Attorney General. The Attorney General is responsible for the management of listings. The Attorney General goes to court under Section 22 in its several iterations, 22AA, 22BB, 22B, etc. The Attorney General goes to the court and seeks to tell the court, listen, we need to list an individual or an entity. They come from the UNSCR recommendations, or they come locally, and the listing allows the Attorney General to go to court, ask a court to list these people, and effectively then freeze their assets or freeze their accounts. Once the order is made, the FIU receives it, publishes it widely, and then all banks and supervised entities, etc., get the message: X entity is to be cautioned not to do business with Y entity. So whenever you see that red flag pop up, you know not to do it. Now, this is a very important tool to protect and also punish. On the punishing side, obviously you don't want to have the financing of terrorism happen. But on the protecting side, many of our Islamic entities in particular engage in zakat, engage in supporting international agencies which are properly supervised, but there are vagaries in the world. The United States may blacklist someone, the United Kingdom may not, and our citizens have found themselves complaining that they are victims of blacklisting because they've provided zakat quite legitimately to certain entities which are approved by the United Kingdom but not by the United States. So having our courts have the listings allows us to tell our citizens when they are blacklisted, we get to make representations on their behalf to say, listen to the international agency, you've got it wrong. These people are complying, they are known, these entities are supervised, they're listed or not. The model that we've used here in amending the Anti-Terrorism Act to put in this desk is to take advantage of the work which I have had the great pleasure of leading at the AG's office in the period 2010 to 2015. Effectively, the Anti-Terrorism Act lay as a virgin bill. There was no activity at all, not a single listing. Since then, we have engaged in 506 listings, and we've brought it to life. It would be a tragedy if that were to allow itself to continue on the passion or will of Attorney General to Attorney General. I'm in a revolving door. The next Attorney General in Trinidad and Tobago ought to have the benefit of an established desk in the same fashion that we have a central authority to operate the Mutual Assistance in Criminal Matters Act, extraditions, etc. We've modeled this from the extradition bases, etc., for the central authority, and that's the hat on the peg that we have chosen, Madam President. Madam President, we asked specifically that the AG produce a report, and this is to be found in Clause 3C. We're asking that the Attorney General produce a report because the Minister of National Security already produces a report in Section 43 of the Act, but there's nothing to require the Attorney General to speak to the statistics that the anti-terrorism desk will perform. So we've thought, by way of transparency and by way of reporting, that we should cause the Attorney General to produce a report and lay it in Parliament in the usual fashion. Madam President, the provisions of Clause 4 are really just cross-reference checking. Clause 4, we propose in Clause 4.1 that we amend Section 8.3d of the Financial Intelligence Unit Act. There were cross-reference errors. It should not be 55.3, it should be 55A, and we've sought to correct that. Clause 4.1, we amend Section 19 of the FIU Act. We're deleting the words Section 55.7. Again, this was due because we had done certain amendments which rendered it otiose, and it was therefore required to be removed to make sense of the law. And in Clause 4.2, we amend Regulation 2 in correcting a cross-reference, moving away from 55.3 to 55E. So, Madam President, in the round, we have a deadline. I apologize that we are sitting in the Senate today, the 19th of December. We could not have come sooner. It has come about by way of the constant operations of the Attorney General's office with the assessors. Once they were rendered certain, we came with immediacy. We're proposing amendments. Number 1, to treat with our mutual evaluation report recommendations and improvements. Number 2, our high-level commitment and goalpost markers that we've subscribed to. Number 3, having reported on November 30th, as I cautioned we would have, we have an occasion to be ready on January 4th to treat with this law and to report to our assessors that we've done what we have. We're seeking to systemically improve the proceeds of crime operationality by having the National Anti-Money Laundering and Financing of Terrorism Committee in operation in law. We're improving the Anti-Terrorism Act by having the Office of the Attorney General replicate the work of the Central Authority in a specialized division. We're correcting cross-reference errors. We are improving fines and penalties. We're easing up suspicious transaction management to make sure that you don't find yourself tripping things unduly, worrying about whether you must prove that a crime existed or not. We are improving group consolidation, because there was a lacuna in the law where you could probably argue in a consolidated group, a financial group, let's take Republic Bank Holdings versus Republic Bank itself. If Republic Bank itself was talking to its legal officer in Republic Holdings about a matter, that could be viewed as tipping off. So we had to make sure that we dealt with the vertical arrangements in group consolidated management to allow for no tipping off if you're doing it in good faith and in the lawful circumstances of STR-SAR management. This world of the FATF is filled with anachronisms. It is filled with obligations. It is filled with inconsistencies. You're fighting civil law versus common law. It is filled with abbreviations. You have to learn up the technology and be technologically speak proficient as fast as you can. When you get to the FATF world, you have to know what a FSRB is, ICRG is, PDG is, WIG fee is. I mean, the terminology alone is a lexicon in itself. So what I can say to the honorable senators is the country has been diligently performing its work. We have come in for recommended praise by our international assessors. We are on the right track. The international obligations and complying with them is not trading our sovereignty. We in the government of Trinidad and Tobago, and we the citizens of Trinidad and Tobago, I am sure, all agree that following the money, stamping out corruption, moving money laundering, improving our courts, making sure that the financing of terrorism doesn't happen. We all agree that those are local goals that we must ascribe to and apply for ourselves. So, Madam President, I look forward to the contributions of my learned colleagues. I do hope that if there are some immovable fixtures in their minds, that we can discuss it through, because it is definitely a difficult task to manage this affair, and I look forward to contributions and beg to move.
Honourable Senators, I shall now propose the question for debate. The question is that a bill entitled An Act to Amend the Proceeds of Crime Act, Chapter 11, 27, the Anti-Terrorism Act, Chapter 1207, and the Financial Intelligence Unit of Trinidad and Tobago Act, Chapter 7201, be now read a second time. Before I call on Senator Ramdeen, I will now revert, as I indicated before, to item 14 on the order paper, Leader of Government Business.
Thank you very much, Madam President. Madam President, having regard to the interim report of the Joint Select Committee appointed to consider and report on the Constitution Amendment Tobago Self-Government Bill 2018, I beg to move that the committee be granted an extension to May 27, 2019 to complete its work and submit a final report.
Honourable Senators, the question is that the Joint Select Committee appointed to consider and report on the Constitution Amendment Tobago Self-Government Bill 2018 be granted an extension to May the 27th, 2019 to complete its work and submit a final report. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Leader of Government Business.
Madam President, having regard to the interim report of the Joint Select Committee appointed to consider and report on the Trinidad and Tobago Revenue Authority Bill 2018, I beg to move that the committee be granted an extension to February 28, 2019 to complete its work and submit a final report.
Honourable Senators, the question is that the Joint Select Committee appointed to consider and report on the Trinidad and Tobago Revenue Authority Bill 2018 be granted an extension to February the 28th, 2019 to complete its work and submit a final report. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Senator Ramdeen.
Madam President, good afternoon, and thank you for the opportunity to contribute to this debate on an act to amend the Proceeds of Crime Act, Chapter 1127, the Anti-Terrorism Act, Chapter 1207, and the Financial Intelligence Unit of Trinidad and Tobago Act, Chapter 7201. Madam President, we are here again this afternoon to debate a piece of legislation that, like the Attorney General has said, has twin aims in terms of the satisfaction of our international obligations and the strengthening of our domestic legislation in order to fight the scourge, as the Attorney General says, of financing of terrorism and anti-money laundering. And I want to say at the outset, Madam President, the Attorney General made much of the principal piece of legislation that we are asked to amend today, which is the Proceeds of Crime Act. And I want to give the assurance to the Attorney General that the aims that have been set out in the Proceeds of Crime Act, which was Act number 55 of 2000, since the year 2000, we're in the year 2018, this piece of legislation is 18 years old. But that piece of legislation was passed at a time when the world was moving towards fighting financial crime on a different basis. Legislation was brought to the Parliament of Trinidad and Tobago, which we subscribed to. That piece of legislation was amended by Act number 10 of 2009, Act number 17 of 2012, and Act number 15 of 2014. And Madam President, every administration, whether it be the People's Partnership, the People's National Movement, the United National Congress, shares the view and shares the noble aims of fighting money laundering, corruption, and the fight against terrorism and the financing of terrorism. And when one looks at all of the internet, we have come here time and time again, and the Attorney General has brought piece of legislation after piece of legislation because, as he has said, the Global Forum, CFATF, and FATF, and the 40 recommendations that we are required to comply with. Those are part of our international obligations. But I want to set one thing straight here this afternoon, Madam President, on this, what might be a short bill, but has very far-reaching consequences. To say it has been said time and time again that we were put into this position of finding ourselves where we are now with these recommendations for fourth round evaluation. by the People's Partnership Government between 2010 and 2015. And I know that the Attorney General will agree with me in saying that it didn't matter who was the administration in power between 2010 and 2015, because these requirements, these international requirements that we signed on to at that point in time, the Attorney General said we are not sacrificing our sovereignty. But it matters not which administration was in power then, Madam President. We were required to meet these global standards. We signed on to them. As a country, we are part of an international community. That international community, that international village is becoming smaller and smaller on a daily basis, and we have to comply with our international obligations. At the same time, Madam President, the moving target that the Attorney General speaks about, and we are being brought here, I mean, I myself confess that I'm sorry that the new members on the independent bench have to now grapple with preparing for this debate today. The Attorney General was kind enough to indicate that he apologized for the shortness of time. But, Madam President, these amendments, for lawyers who are versed with legislation every day, it is difficult for us, much more so for persons who are not legally trained, to be able to contribute in a meaningful manner for the benefit of not the independent bench or the opposition or the government, but for the people of Trinidad and Tobago, because we are here to perform a task not on a partisan basis. We are here to perform a task on behalf of the people of Trinidad and Tobago. And I too, not that it is my duty, but I too feel for the new members on the independent bench, having received this bill last night as amended in the House of Representatives and being asked here. And it's not a criticism of anybody, Madam President, not being said in a pejorative way. But at the end of the day, in order for us to meaningfully contribute to what we all want as the best product out of this legislative lawmaking process, it takes a little bit of time. And we all left here at the wee hours of the morning last night, reaching home at the wee hours of the morning. We all, and this is not complaining, Madam President, this is just understanding that we are here to do the people's business, and what we are here to do is very serious. I asked the Attorney General before the debate started today in relation to one of the amendments, and we were graciously provided with the material of what is the consolidated version of the proceeds of crime. And it is very difficult to understand, Madam President, because these pieces of legislation have gone through amendment after amendment after amendment. And when we come here and we are asked to amend again another piece of legislation, one has to have a holistic understanding of the different pieces of legislation and how they mend and mesh with each other in order to understand the legislative aim at the end of the day that we are being asked to perform and to carry out. But, Madam President, I've heard the Attorney General indicate what our international obligations are. And in every single debate that we come before this Parliament, this Senate, that we contribute to, it must be, it cannot be otherwise, that our aim has to be to fight these scourges of corruption, money laundering, and the financing of terrorism, not simply by passing legislation, Madam President. Passing the legislation is one good step to be made in the right direction. No one can doubt that. But where do we go after we pass the legislation? The Attorney General importantly has said that one of the ways in which the present government's policy is to drill down and to make some of these offenses summary offenses so that the magistrate court will be able to deal with some of these offenses. But I want to take this in a step-by-step approach, Madam President. The reason why we find ourselves in a position of non-compliance is because FATF and CFATF, it cannot be that they are simply giving us these 40 recommendations, say, change your laws, comply with these 40 recommendations, and that's the end of the story. It doesn't work like that. Because if that is the end of the story on an international basis, it serves no benefit to Trinidad and Tobago if we have legislation that was passed in the year 2000 This legislation that we are asked to amend today, Madam President, this proceeds of crime, which is the heart and soul of the fighting of corruption and anti-money laundering, was passed by UNC administration in 2000. So it doesn't matter which administration is in power. This is a theme that has gone on for the last 18 years. But you know what is disturbing? The Attorney General will come and he tells us the wheels of justice are not moving fast enough. When we were in the last session, every piece of legislation that comes forward, there would be a hue and a cry by the independent bench saying, in respect of white-collar crime, nothing is happening. White-collar crime is committed, but it's really not a crime in Trinidad because nobody is prosecuted. I asked a question of the Attorney General 2 sittings ago, and the Attorney General confirmed, we have an investigation that centers around this piece of legislation ongoing in this country for 11 years now. This year will make 11 years. This country has spent over $500 million on an inquiry. And after 11 years and over $500 million, not a single person has been charged. And that is the problem. The problem and the question that we must ask ourselves is, are we going to continue amending our laws, strengthening our legislative framework, and then we still get no results? Because as the Attorney General says with these moving targets, when you pass the test on the 4th of January 2019, and they say, okay, you've gone past one hurdle, there is going to be a point in time when you will, as an administration and as a country, we would have carried out the 40 recommendations of CFATF, you know. And then we would be asked, well, what next? Are you all prosecuting anybody for money laundering, for the financing of terrorism? And that takes me, Madam President, to the report, the very important report that is produced by the Financial Intelligence Unit of Trinidad and Tobago, the 2017 annual report. And I just want to start, I want to examine a few things in this report, Madam President. But you know, the Attorney General has said that between 2010 and 2015, these laws were stagnant. Nothing was done. But I found an interesting part of this report, Madam President, at page 48 of the FIU report for 2017. And because I've been hearing this over and over about the stagnant, nothing was done between 2010 and 2015, I just want to put on the Hansard that between 2010, well, let me be more specific, between the 13th of November 2012 and the 8th of July 2015, there were 16 memorandums of understanding that were signed on by the FIU with our international partners to fight exactly what we are engaged in today. And let me just, for the record, deal with that. We signed on with Jamaica, St. Vincent and the Grenadines, Guyana, Montserrat, St. Martin, Suriname, Bermuda, Canada, Bangladesh, Taiwan, Grenada, Dominica, the Dominican Republic, Antigua Barbuda, Turks and Caicos, South Africa. 16 MOUs were signed. So that, let it not be said, Madam President, perhaps we didn't do it fast enough. Perhaps more could have been done. I don't think any administration, Madam President, could say that there was a perfect job done with respect to the legislative agenda to fight these things. It cannot be. But, Madam President, what is this? There's one troubling thing about this entire affair. It is this, that despite all the laws that we are being asked to pass, despite all the amendments to the legislation that deals with the fight against money laundering, financing of terrorism, proceeds of crime, there is a gaping hole in relation to prosecutions. And we have to ask ourselves, well, why? It cannot be that the Attorney General is satisfied with the position that we find ourselves in, which is we have the strongest laws, we are improving our courts, we're giving all the financing that is needed to the FIU, the FIB, the Trinidad and Tobago Police Service. And then when we ask ourselves, what has the people of Trinidad and Tobago gotten as the product for this? The answer is absolutely nothing. And I'm disappointed that that is the position. And that is not the fault, Madam President. I want to make it clear at the outset that we are going to find ourselves in a position of whether they want to call it being on the green list, sorry, the gray list, or the black list, or whether we are in a position of non-compliance. We are going to continually find ourselves in that position until we understand that the goal that we must set ourselves is not passing legislation alone. It is not simply improving the criminal justice system, but it is bringing to justice the people who are in breach of these laws. And I know that the Office of the Director of Public Prosecution is one that is insulated under Section 90. Nobody could tell the DPP what to do, when to do it, how to do it. But I'm telling you, Madam President, the time is coming in this country where the Office of the Director of Public Prosecution has to be accountable to the people of Trinidad and Tobago. And it is because, as they say, Madam President, we who are lawyers understand, with rights goes responsibilities. We as a country took a decision to have an office that is in charge of the prosecution of all criminal offenses in this country. Because of the differences that we had at independence and when we became a republic, we decided to totally insulate that office for totally rational, reasonable, and understandable reasons. That is an office that should be independent from any administration. It should have absolutely no political interference. But what we didn't consider, Madam President, is that while we were focusing on insulating that office, we never as a country put in place a mechanism for accountability for that most important office. And that is why today, when we find ourselves in these positions, we are being put as a nation in this position. Why? Because it's just like the fight against drugs and crime. We have legislation that deals with dangerous drugs. Every village you go into, every town that you go into, every part of Trinidad, the ordinary citizen could tell you who running the drugs, who in the drug blocks, who are the drug dealers, but the only people who can't have or don't have that information is the police. Thankfully, Madam President, there are some of us in this Parliament that understand that the fight against crime is not about PNM and UNC. When somebody goes into your house to rob and shoot and kill you, they don't check and see if you're wearing yellow or if you're wearing red or if you're green. It doesn't matter, right? It is a scourge that affects all of us. So it is not about why this one didn't lock up this one or that one didn't lock up that one. Because before 2010, right, the PNM was in power as well. So the same question that is being asked now, why you didn't lock them up when you was in power? I could ask the same question too. Why you didn't lock them up when you were in power? That is not what we are here for, Madam President.
Why you lock them up now?
What we are here for, and I want to raise this frontally with the Attorney General, is this.
It's a national fight.
The only way we will improve the fight against all of these things that we are asked to improve here today is for us to have prosecutions of people who are in breach of the law. The Attorney General has told us that the government is taking a whole-of-government approach, and therefore the de-siloing is taking place and information is being shared. But, Madam President, I'll tell you what is not good. Hold on. What is not good is this. At the Office of the Director of Public Prosecution, who is on the NAMLAC, who is the heart and soul of the proceeds of crime. There's a whole section that all the powers belong to the Director of Public Prosecution. The Anti-Terrorism Act, the Attorney General correctly said, is one of 3 agencies that is in charge of operationalization of that piece of legislation. Let's see what the position is at the Office of the Director of Public Prosecution, Madam President. As of the 15th of August, 2018, the position at the Office of the Director of Public Prosecution is this. There are 2 vacant positions for Deputy DPP. There are 4 vacant positions of Assistant DPP. there are 13 vacant positions for senior state counsel. There are 12 vacant positions of State Counsel 3. There are 38 vacant positions of State Counsel 2. And there are 5 vacant positions of State Counsel 1. So the total in relation to the staff complement at the Office of the Director of Public Prosecution, Madam President, is this. There are a total of 128 positions there in that office that is in charge of prosecution of all crime in Trinidad and Tobago. And as we speak today, and we are asked to improve the criminal justice system, out of 128 positions, 55 are filled. 55 out of 128. So you have 73 positions, 73 that are vacant. Well, Madam President, it doesn't take a lawyer, it doesn't take an attorney general, it doesn't take a senator to tell you that if you have 73 positions out of 128 not being filled, then you obviously have a problem. And the problem that you have is we will pass all of this legislation and we will get absolutely no results for the people of Trinidad and Tobago for it, because the people who are in charge of, we already have a problem with detection, we already have a problem with prosecution, but in the realm of prosecution, the people who are independent and charged with the ability to prosecute all of these offenses that we are creating by the proceeds of crime and the amendments here today, we have 73 positions that are vacant. Well, Madam President, let us not put the cart before the horse. The position is this. Unless we resource the offices that are to operationalize these pieces of legislation, colloquially, as they say, we spin it up in mud. We are doing absolutely nothing. And if we think that by the passage of these pieces of legislation, the satisfaction of our international obligations are going to bring any relief to the ordinary citizen of Trinidad and Tobago, then we're fooling ourselves. And so, Madam President, let me say at the outset that I want to call on the government to do all in its power to resource the Office of the Director of Public Prosecution and to forthwith do all that we can to fill the 74 positions that are vacant there, the 73 positions that are vacant there. Because, Madam President, we come here in every debate and talk about the criminal justice system. We open in more courts. We put in more staff there. Everything in the criminal, we pass in legislation. Everything that is being said, all of that is good. But at the end of the day, if we don't resource the most important office that is in charge of doing the work and bringing results from these pieces of legislation, we are not going anywhere. We are in an exercise of total futility. And while we can say, fine, we satisfy CFATF and we satisfy Global Forum and we satisfy the 40 recommendations, like I said again, that is not going to bring any relief to the people of Trinidad and Tobago. And let me explain, Madam President, how that position has morphed itself in this country. In this same report, the 2017 annual report of the Financial Intelligence Unit, which is the unit that has to operationalize all these amendments that we are speaking about here today, you know. In 2017, the report says, and I'm reading from page 12 of the report, in this reporting period, that is 2017, the FIU received 877 STRs and SARs, a record number of disclosures, reflecting a significant increase of 19% from the 739 received in the previous reporting year. Consistently, the banking and money value transfers services sector were the most active reporting entities, accounting for 81% of total STRs and SCRs. And this is the important part, Madam President. The record number of 877 disclosures showed that an unprecedented monetary value of over $22 billion in suspected proceeds of criminal conduct This is an unprecedented increase because the cumulative monetary value of suspicious transactions reported for the previous 5 years was only 4.5 billion. So, obviously, the FIU is doing their job and picking up all of these suspicious transactions. But the question that we ask again, Madam President, is this, and I will get to that now. Since you are picking up all of these suspected transactions, these suspicious transactions, one would expect that with all that evidence, or let me put it another way, more correctly, with all of that information, somehow that information will turn itself into some form of evidence that somebody is going to be prosecuted. But, Madam President, when you come to the prosecutions of people under these, for all of this $22 billion, the entire arm of the state, with the Trinidad and Tobago Police Service working hand in hand with the FIU and the FIB, the persons prosecuted for offenses over this period of time is less than 1%. Less than 1% of the value. So, Madam President, doesn't it tell us that something is not right? Doesn't it tell us that why is there this gap between the gathering of the information and the prosecution of persons? Madam President, just as how difficult it is for us to accumulate all of the amendments in these different pieces of legislation, I want to ask the Attorney General today, when all of these summary offenses are created and the magistracy is charged with carrying out the adjudication as to the guilt and innocence of these people, and the laws are being transformed on a daily basis, Madam President, what is the state doing about the continuing judicial education of magistrates with respect to the implementation and the adjudication upon all these charges that we are creating by these offenses? Are we going to just wake up one morning and realize that the magistrates themselves have all understood all the amendments to the different pieces of legislation? They have been versed in all of the provisions with respect to financial crime, all of the sentences that are available. And like I said before, abracadabra, everything will be fine. That, Madam President, cannot be the solution. Madam President, I want to get down now to the actual clauses in this particular piece of legislation and the amendments to the proceeds of crime. And one of the things that strikes very early when one understands the way in which these different pieces of legislation incorporate themselves is that when you go to the Proceeds of Crime Act itself, Madam President, the Attorney General is proposing that these offenses, let's take the tipping off with respect to the amendment to Section 51, which is Clause 2 of the Act, and the provision that a person commits an offense if he knows or suspects that a financial institution or listed business is reviewing information to determine whether to file or otherwise in the process of filing a suspicious transaction report or suspicious activity report. Madam President, when you go to the Proceeds of Crime Act, and just to demonstrate for those who are non-lawyers and for the people of Trinidad and Tobago, under this piece of legislation, the definition of financial institution is a bank licensed, and this is under Section 2 of the Proceeds of Crime Act, Chapter 1127. The definition of a financial institution is a bank licensed under the Financial Institutions Act, a financial institution licensed under the Financial Institutions Act, a building society registered under the Building Societies Act, a society registered under the Cooperative Societies Act, an insurance company, we're now taking out agent or broker registered under the Insurance Act, a person licensed under the Exchange Control Act to operate an exchange bureau, a person licensed under the Securities Act as a broker, dealer, underwriter, or investment advisor, a person who carries on money or value transfer services, a person or entity managing a collective investment scheme under the Securities Act, development banks, trust companies, mortgage companies, and any other person declared by the Minister by order, subject to negative resolution of Parliament, to be a financial institution for the purposes of this Act. Attorney General, Madam President, through you to the Attorney General. There has to be a great concern that the persons who are directly affected by the amendments to this legislation understand, number one, what we are doing here as a Parliament, understand the direction within which the laws are being amended, and understand the impact that the laws are going to have on their day-to-day activity. And when this legislation is passed, Madam President, I think that a special effort has to be made to educate all of the persons who belong to the financial institutions that are affected by the offenses that are being created by these differing pieces of legislation. And why that is important, Madam President, is because the purpose of the criminal law, as I understand it, is to regulate your conduct as a society. And at the end of the day, you can only effectively do that if the persons who are prohibited from doing certain acts by virtue of these pieces of legislation, a central part of which, Madam President, rests upon the element of knowledge and intent, know as to what transgresses the law and what does not transgress the law. And I've heard, not as though it's a criticism, but I've heard very little from the government as to what are the steps that are being taken to educate those persons who are affected by these different pieces of legislation. Madam President, I then go to Clause 2, Subclause C, which is the amendment to Section 53. And Attorney General, while we've heard, through you, Madam President, to the Attorney General, while we've heard the admission that what is provided there in the proposed new 1A to Section 53 already represents what the common law is and what the Aiders and Abettors Act provides for, there is one particular definition that is not covered by the Aiders and Abettors Act, and neither is it covered by the common law. And it is the element that is included in this definition of facilitates. And, Madam President, when one looks at the Aiders and Abettors Act and one looks at what the common law position is, the common law position may cover the conspire. The attempts, aid, abets, procures is all covered by the Aiders and Abettors Act. But I don't, perhaps it is my feeling, but I don't know that the word or the element, let me put it this way, the element of the offense of facilitates is one that is known to the criminal law and is one that it is not defined by the Act. And therefore, I want to urge the Attorney General to consider whether, having regard to what is contained in an attempt and to aid and abet, conspire, procure, and then you have the omnibus or otherwise facilitates, whether you do need that actual provision when you have already found yourself in a position that the common law provides for these positions, as well as, Attorney General, perhaps I can indicate that in addition to all of these ways in which a criminal offense can be committed, you also have the concept of joint enterprise, which is something that you may want to consider in determining whether you think it is effective to continue with that particular provision. Madam President, I want to, before my time runs out, Madam President, I want to deal with this issue about the Clause 3 and the amendments to the Anti-Terrorism Act, and more particularly the Anti-Terrorism Unit. Madam President, we are told by this bill that there is established in the Office of the Attorney General a unit to be known as the Anti-Terrorism Unit. And as I understand it, Madam President, there are many different units in the Office of the Attorney General. There's a human rights unit, there's a central authority, and we are being asked today to approve an anti-terrorism unit. And when one studies carefully the provisions of the Anti-Terrorism Act, one understands the very detailed tasks and duties that are vested in the Office of the Attorney General with respect to that particular piece of legislation, and perhaps the need for an anti-terrorism unit. But the concern that I have is this, Madam President. We are asked to establish an anti-terrorism unit, and we are told by subsection 2 of Section 38B that the functions of the Attorney General under this Act may be exercised by the Attorney General in person or through a public officer or legal officer who is employed in the unit, A. B. Authorized by the Attorney General in writing, and C. Acting under and in accordance with the general or special directions of the Attorney General. Now, I looked at the Mutual Legal Assistance Act, and I see that under that piece of legislation, the first part of subsection 38B2 is covered in a similar provision. But what I have a difficulty with is this, Madam President. While we are setting up this creature of statute, which is to be the anti-terrorism unit, we are nowhere told what the functions of this unit are to be. And I have a serious concern about that, because while the unit can be an administrative unit in the office of the Attorney General that the Attorney General can exercise powers over and delegate powers to, when you place this unit by statute onto the law books, you circumscribe the unit by being only able to exercise the powers that are given to it by statute. And therefore, we have a concern that unless you put in the legislation what the powers of this unit are to be, well, respectfully, Madam President, this unit can do nothing else but be a group of people from whom the Attorney General can delegate power to exercise the powers of the Attorney General.
Senator Ramdeen, you have 5 more minutes.
Thank you, Madam President. This can only be a group of persons that can exercise the powers that Section 38B2 allows the Attorney General to delegate under the Act. But apart from that, on my reading of what this provision provides, this unit and whoever is comprised in this unit, and there must be people comprised in the unit because the provision says the functions of the Attorney General under the Act may be exercised by the Attorney General in person or through a public or legal officer who is employed in the unit. So it assumes that you're going to have public officers there and legal officers there. But, Madam President, unless we flesh out in the legislation what are the powers of the persons who are going to be employed in this unit are to do, then those people have no power. And the unit will really be useless, save and except to exercise delegated powers of the Attorney General. So, Madam President, I want to caution and I want to ask the Attorney General if it would not be better for us to flesh out in a subsection 4 what are the powers that this unit is going to be exercising. It is already a unit of an arm of the executive, and therefore we want to be sure that whatever powers the unit is exercising doesn't transgress the powers of any other office or entity of state. And I think that is a caution that we must pay heed to. Madam President, we will come time and time again to the Parliament to satisfy this moving target of the Global Forum, the FATF and the CFATF requirements. And the only way that we will be able as a country to effectively reap the benefits of the work as a Parliament, as a legislature that we are required to do, is if we resource the entities that are supposed to carry out the functions of these particular pieces of legislation. The Attorney General, when I read his contribution in the other place, read out what are the resources that are being given to the FIU, how the financial resources given to the FIU have increased over the period of time, and one expects that in this report that the FIU has done in 2017, there are a number of shortcomings that have been identified, and one hopes that the government will resource the FIU to be able to come up to speed and to meet all the aims. There's a special section that deals with all the aims for 2018 and 2019 moving forward. So one hopes that that will be done. But more importantly, Madam President, I want to end my contribution on this piece of legislation by saying that we will reach nowhere as a country passing laws time and time again, amending the Anti-Terrorism Act, amending the Proceeds of Crime Act, bringing new pieces of legislation to better the criminal justice system, amending the Bail Act, building more buildings, renting more buildings, bringing more courts, putting more cap reporters in the courts, when at the end of the day, when you ask yourself what is past the equal sign to all of this, the answer is zero, because the country is still waiting to see who is going to be prosecuted and who is going to be charged. And the people who are benefiting from criminal activity in Trinidad and Tobago to the extent of $22 billion are as free as the birds. And all we are being asked to do is pass piece of legislation after piece of legislation. The time has come, Madam President, for us to not only, as a country, resource these entities. The time has come for those people who have responsibility for carrying out the state function of prosecuting people for the commission of criminal offenses in this country to account to the people of Trinidad and Tobago. And when that office is accountable, whether it be to the Parliament, to the people of Trinidad and Tobago, then we will be able to see the results of all of these pieces of legislation. And it may well be, Madam President, as I have said before, when people start being prosecuted, we will meet our international and domestic obligations with flying colors. We wouldn't be on any green list, blue list, gray list, or black list. We might be on the white list, and we might be an example for others to follow. I thank you, Madam President.
Senator Teemal.
Thank you, Madam President, for the opportunity to contribute to this debate. Madam President, I had a small bit of trepidation about entering this debate for two particular reasons. One, I think Senator Ramdeen mentioned the very short time we have had to review the proposed bill and prepare for the debate. But probably more, the other reason is that the bill would suggest heavy input from legal minds, from the lawyers. And I'm from the profession of engineering. But, of course, engineers being exposed to contract administration and some bits of contract law, we fancy ourselves a lot of times as lawyers. And although when matters do get complicated and it goes to arbitration and court, engineers are often chided by judges and legal minds for being a bit too adventurous in terms of knowing the law. So to borrow some terminology from Senator Mark, my contribution really is given in the context of what we would call bush lawyer. Yes, good and safe. Madam President, on page 2 of the proposed bill, clause 2, section B, item 1, by inserting after subsection 1 of the following new subsection 1A, it says a person commits an offense if he knows or suspects that a financial institution or listed business is reviewing information to determine whether to file or is otherwise in the process of filing a suspicious transaction report or suspicious activity report. And in terms of the use of the word suspects, the question is, because most of my contribution would be seeking clarifications and asking questions, which hopefully will be addressed by contributions from the government bench and wrap up by the Attorney General, is by suspects, whether suspicion is indeed a sound basis and whether just suspicion leaves the room for mischief against those who are intent on bringing into disrepute businesses and other persons. Other than that, if we look at the NAMLAC, the National Anti-Money Laundering Counter-Financing of Terrorism Committee, what is proposed here, going through this, and looking at it particularly in terms of an amendment to the Proceeds of Crime Act, and seeing that it really comes primarily from the need to fulfill the compliance requirements of the FATF that we have to comply with, according to what was explained to us at the beginning by the Attorney General. And looking at the purpose that is outlined on page 5, item A, making recommendations to the Minister in relation to the development and 2, coordinating the implementation of national anti-money laundering, counter-financing of terrorism, proliferation financing policies. And then particularly B, for collecting and compiling statistics with respect to anti-money laundering, counter-financing of terrorism, and proliferation financing. Madam President, in Clause 9 of the Financial Intelligence Unit of Trinidad and Tobago Act, particularly Clause B of Section B of Clause 9, it appears to me that there's a large extent of duplication here in terms of the responsibilities of the FIU and what is being proposed here for NAMLAC in terms of the collected and compiling statistics, because Clause B of Section B of Clause 9 speaks about maintaining comprehensive statistics, this is for the FIU, regarding money laundering and financing of terrorism. So there seems to be significant overlap in terms of the purpose of the NAMLAC and the direct responsibility or purpose of the FIU under the FIU Act. And of course, point C of the purpose, Clause C, for coordinating the conduct of national risk assessments and mutual evaluations, which seem to me to be the major purpose, really, of the NAMLAC in terms of risk assessments and mutual evaluations, which puts it distinct from the responsibilities of the FIU. Another point I would like to raise is under the FIU being established primarily for implementation of the recommendations of FATF and CFATF on money laundering and financing of terrorism is an explanation. I would ask a question as to why this amendment, this particular NAMLAC amendment, is being proposed under the Proceeds of Crime Act rather than the Financial Intelligence Unit of TNT Act. I'm sure a lot of thought would have gone into it as to why. And probably in the wrap-up, we could probably get some of the insights and the reasons as to why, because the minister directly responsible for the Finance Intelligence Unit Act, the line minister there is, of course, the Minister of Finance. And under the Proceeds of Crime Act, what we have here, the minister is, of course, the Minister of National Security. So in terms of the necessary coordination amongst the various ministries and the respective agencies that have been established for compliance, particularly under the FATF and the CFATF, I am just asking further clarification as to why this is being positioned under the Proceeds of Crime Act. Another thing is that under NAMLAC Clause 2, the composition of the committee is laid out there. And although I acknowledge under item B of Clause 2, where it says, such other persons as the minister thinks fit, that's in terms of who the members would comprise, there is no distinct mention in the composition of the committee I don't know if it's an omission or there's specific reason for it, of the Comptroller of Customs in terms of the membership being proposed here. And of course, I think we would agree it's a key and strategic agency within the whole framework of what we are looking at. In terms of clause 4, we're on page 7, where it says the minister shall appoint the chairman and deputy chairman of the NAMLAC from amongst the members of the NAMLAC. Again, if in terms of this NAMLAC being established primarily for the implementation of the recommendations of the FATF, would it be appropriate, most appropriate, that the chairman or the deputy chairman, rather than leaving it a bit open like that we be a bit more specific and for the chairman and vice chairman to be nominated from one of the more relevant agencies listed as listed above in terms of comprising the membership, maybe the FIU or some directly related agency amongst all those that are listed here. One other thing, Madam President, is the question of reporting. I see no provisions here in terms of reports to be generated by NAMLAC, by who has the direct responsibility and who the reporting is to be done to. The reason I raise it is particularly in terms of item C of the responsibilities, which I mentioned before, for coordinating the conduct of national risk assessments and mutual evaluation. And if NAMLAC, one of the major purposes is really risk assessment, and risk assessment of all of the agencies and the entities that are connected with this particular act. Of course, any risk assessment is going to give the results as to where the respective agencies are in terms of compliance. And seeing that this bill is particularly about ensuring compliance, then I think that the reporting should be clearly defined, the frequency of the reporting, the party responsible for the reporting, and to whom the reporting should be done. And it should be defined within the amendment that we are considering. Madam President, I'd like to move on to the proposed amendment, the Anti-Terrorism Unit on page 8. And my first impression when I saw it, my first take on it, coincides with that of Senator Ramdeen in terms of what he was expressing, in terms of what is the mandate of this, what is the proposed mandate of the Anti-Terrorism Unit? What is its distinct purpose? Because under the Anti-Terrorism Act, the powers of the Attorney General are very clearly spelled out, particularly under Clause 22B, in terms of the powers of the Attorney General under this Act. And what I would like to ask is that, seeing that we have an anti-terrorism desk in operation at the Office of the Attorney General since 2015, I believe it is, doing wonderful work. I think the Attorney General mentioned the number of listings that has been done thus far by the anti-terrorism desk at that particular office. Is that what is driving the need to legislate an anti-terrorism unit when there's an anti-terrorism desk within the Office of the Attorney General fulfilling the mandate under the Anti-Terrorism Act. I thought for a moment that when the Attorney General was giving his brief, when he was introducing the bill, he mentioned about bringing it into legislation because of continuity. Now, if that is one of the objectives, I would support that, because we all know one of the major problems that we have in our country is continuity. Because when governments change, a lot of things that are put in motion by the previous government, for some reason or the other, they are scuttled and it's not continued. And that lack of continuity with particular projects, with particular legislation and everything has telling effects and very costly effects on our nation. So if it ties in with continuity, I would want to support that aspect of it. But in that support as well, I think clarity in terms of the definitive purpose of the anti-terrorism unit should also be considered for inclusion in the amendment. Madam President, this is my contribution to this budget, and I thank you very much.
Minister of Public Utilities.
Madam President, I stand and join this debate on this bill is a miscellaneous provisions bill which represents the continued implementations of this administration's action plan to meet its international obligations relative to corruption, terrorism, and money laundering, whilst improving and laying the foundation for better dealing with white-collar crime. This bill, in its form, as was previously said, seeks to amend the legislative framework upon which this country has sought to treat with corruption, terrorism, money laundering, namely the Proceeds of Crime Act, Chapter 1127, the Anti-Terrorism Act, Chapter 12.7, and the Financial Intelligence Unit of Trinidad and Tobago Act, 2701. You know, before delving into the bill itself and its different clauses, I must say that I want to stand and congratulate, the contribution of my learned colleague, Senator Ramdeen. And I really was very heartened by some of the realization that he has come to and what was actually being said by him. And I join in supporting a lot of what he was saying, in that one of the points that was clearly being articulated is the need for us to get to the end game and to produce the type of results which is prosecution. Now, like everything else, there is no one single approach or no one single answer. And I don't think we are being fooled in any way believing that legislation by itself is going to be the do-all and end-all. That we agree is not what it is. In fixing a problem, there is no one particular solution. We here today, however, are called upon to deal with the legislative framework, which needs to be done in conjunction with a number of other things that also needs to be put in place. But you're right. Part of the problem that we have is an institutional problem, and it's glad to see us in this legislature talking about things like that, because we move from one administration to the other administration, and we recognize that at the end of the day, we have to service the people. And there's some fundamental problems. He spoke about the DPP's office and the need for it to be held accountable. Well, that's just one institution that needs to be held accountable. There are all the service commissions that are wrong. And those things that we set up way back in our Constitution when it was drafted, because of the fear that we had for our own selves and our lack of confidence in ourselves to really govern ourselves, we put these things in place. And like we all know, if you have a marriage or you're building a country and you have husband and wife taking two positions all the time, the people who end up losing out are the kids that fall through the cracks. And we have been a country as a nation for over 56 years. And if you look back at us, we'll recognize that over that 56 years, because of those commissions that we have had, productivity is not what it used to be before. How we approach our work, how we approach the disciplining of our staff, of the people. When you look at what has happened as in the service commissions and what is happening in our police service, I mean, we looked at a particular report done by the Deoroop report on the Human Resource Committee, and a lot of the information that was being shared by Senator Ramdeen about the DPP office came out of discussions that we had at the Joint Select Committee, where a lot of those information came out. But it's no different. During those discussions in that committee, we found out that a lot of what was happening in the police service came about as a result of a lack of oversight and a lack of quick decisions being taken in that particular area. So all our structures need to be looked at. The DPP office, we found out in our conversation, yes, there are lots of vacancies in the DPP office, but we also found out, if you ask the question about the amount of annual appraisals that are outstanding, that needs to be done, the lack of recommendations for promotions that are not coming forward. So there was a myriad of reasons, right, that came and was brought before us, and our system, as we have it, is not producing the type of results that we want in critical areas of our operations as a country. And we need to find a way among ourselves as legislators, as leaders, of how we are going to come together to fix that particular problem. So I look forward to when the necessary legislative change come forward, or discussions about what is the constitutional change that we need to do, not only to hold the DPP accountable, but how do we fix all the service commissions, the teaching service commissions, the public service commission, the police service commission. Are we really happy 56 years thereafter with what we are, where we are as a country, having been governed in this particular way? So there's a lot of work to be done, and as I said, I really congratulate and I look forward to us continuing that type of conversation in this noble house. As the Attorney General mentioned before, we are basically on a plan. We are governed by a number of these international, we have a responsibility to a number of these international legislations that are out there. I mean, what is close to us, the two major ones that are the focus in the Caribbean region, of course, is the FATF and the Global Forum and the CFATF. And basically, as much as we want to say we are an independent country, we share some of the ideals by signing up to these organizations, and not everything that they have put forward is bad. But the reality is we have to find ourselves to be part and aligned to it, otherwise you face the consequences of being delisted. As was said, in the case of FATF, We know and we heard about the 40 recommendations that were put forward for us to look at. And as I said, FATF did a risk-based assessment of the country, and they came up with 40 recommendations. A little bit more information on that. I mean, based on my reading of the document, that evaluation done in 2015, of the 40 recommendations, we were fully compliant with 12 of the 40 recommendations. We were largely compliant with 13, we were partially compliant with 13, and we were non-compliant with 2 of those recommendations. Basically, for my presentation here, I looked at this bill and I identified 5 objectives of this particular bill. And I tried as much as possible to see how then are these objectives being met by the different changes that we are proposing in this particular, the bill before us. And the main objectives were to correct deficiencies in the legislative framework governing corruption, terrorism, anti-money laundering, thereby bringing Trinidad and Tobago in full compliance with certain FATF recommendations. Objective 1. Objective 2, to facilitate efficiency in the systems and the strengthening of the existing protections for stakeholders in the system. Objective 3, to provide a statutory mechanism for ongoing policy development for measures to treat with terrorism, anti-money laundering, and the monitoring and evaluation of the implementation of FATF. Objective 4, to strengthen the capacity of the Office of the Attorney General to fulfill its statutory mandate relative to anti-terrorism. And Objective 5, to strengthen the national legislative framework as part of the crime-fighting mechanisms in Trinidad and Tobago. So how does this bill go about achieving these 5 objectives as stated? The first objective of this bill was, and I repeat, to correct deficiencies in the legislative framework governing corruption, terrorism, and anti-money laundering, thereby bringing Trinidad and Tobago in full compliance with certain FATF recommendations. When FATF did their evaluations, some of the recommendations that came forward from them and the ratings that we got and the factors that they saw causing the rating were as follows. One of them related to money laundering offenses. And in that particular category, we got a rating of largely compliant, LC, largely compliant. And the reasons why we got that particular rating were as follows. One, is that there were no specific provisions in the law for facilitating as an auxiliary offense to money laundering. And secondly, there were no specific penalties for a legal entity. So those were 2 of the reasons why FATF gave us an LC in that particular area. In the area of one of the recommendations were recommendation 21, tipping off and confidentiality. And again, one of the reasons, again, we were LC in that particular area. And again, the reasons that the factor was the offense of tipping off is only applicable where suspicious transactions report STRs and suspicious activity report SARs is being filed. So those were the recommendations and those were the implications of what they saw. So basically, if you look at what we are doing with regard to fulfilling those objectives, recommendation number 3, Section 53 of the Proceeds of Crime Act, POCA going forward, is amended by Clause 2C1 of the bill, which creates the offense of facilitating money laundering under Section 44 and 45 of the PCA. And Section 57.2 of the POCA is amended by Clause 2H1 and 2 of the bill, which removes all doubt that a company and its officers, directors, and agents are liable to be prosecuted and convicted for an offense committed by the company. Again, allowing, what it is allowing for us to fulfill the objective. Recommendation 21, Section 51 of the POCA is amended by Clause 2B1 of the bill to extend the ambit of the offense of tipping off to include disclosures of information that is likely to prejudice the filing of the STR and SAR with the EIU. You see, Madam President, again, as we would recognize, the offense of tipping off as it presently applies only to, as was explained by the Attorney General, to if it comes to a police officer. If a police officer is doing an investigation and the person is tipped off, the present form or the present bill, that is where tipping off applies. However, we do recognize that you need to get closer to the source, because before the information reaches the police, there's a wide gap. We saw the broad span as to where people get information in filing those SDRs, STRs, and SARs. And therefore, in a bank, having worked there for a number of years, you see a lot of things. And what you want to hold people accountable, because there are other people around, you want to make sure that it is an offense for you when the information is being gathered, because the case could fall down at that particular point. So again, that's a very useful thing for us. It's a very useful thing for the country, but again, it brings us that step closer in being compliant, as was mentioned where they said the offense of tipping off is only applicable when suspicious transactions is being filed. Another one of the objectives of the bill, as I outlined earlier, was to facilitate efficiency in the system and strengthening of existing protections for stakeholders in the system. Again, that was another objective of the bill. And therefore, when you look at some of the clauses in this particular bill, Clause 2B, Clause 2B2 of the bill amends Section 51 of the POCA by exempting the disclosure of information within a financial group from criminal liabilities. And therefore, as the Attorney General mentioned, you are, with the expansion of how you now have into a lot of financial institutions holding companies. And therefore, you have to put structures in place to fill that loophole, because the person, even within the bank, you have a compliance department that is normally headed by someone at the holding company's level. And you want to ensure that someone who is working in one of the subsidiaries, that when they get information, they could freely pass that information upwards without any fear that they might be in any way breaking the law. Clause 2F of the bill amends Section 55B of the POCA by expanding the exemption from liability clause for financial institutions and listed businesses who file STR and SARs with the FIU in good faith, by stipulating that they are exempt from liabilities whether or not any criminal or legal activities occur. So you want to free up people's ability to be able to give information, because that is where these are the people that are interacting, and these are people up front that could get information, and you want to make that as easy as possible. Again, when you looked at the 5 objectives, Objective 3 of the bill was to provide a statutory mechanism for ongoing policy development for measures to treat with terrorism and anti-money laundering, and monitoring and evaluation of the implementation of FATF recommendations. So that, again, the objective, that is one of the clear objectives that we are setting. And if you go through the bill and what it is that we are actually doing, Clause 2I of the bill inserts a new part of the POCA, which establishes the National Anti-Money Laundering, Counter-Financing and Terrorism Committee. This committee is the foundation upon which the Trinidad and Tobago continued success in compliance with FATF and other international obligations related to these areas lies, as it is responsible for making recommendations to the Minister in relation to the development, coordination, and implementation of policies in the area of anti-money laundering, counter-financing of terrorism, and the proliferation of arms. It is also responsible for the collecting and compliance of statistics in these areas and coordinating, and also coordinating the conduct of the national risk assessment. The objective 4 of the bill was to strengthen the capacity of the Office of the Attorney General to fulfill its statutory mandate relative to the anti-terrorism. And again, under the Anti-Terrorism Act, the Office of the Attorney General is responsible for applications for the listing of terrorist entities, certain applications with respect to the exchange of information between countries for persons with links to terrorism groups, and certain applications in respect to the seizures of and forfeiture of property. So Clause 3 of the bill establishes a unit to perform the administrative functions relative to the AG's role, anti-terrorism activities. So again, we are fulfilling our objectives as set out. The 5th objective of this bill really was about strengthening the national legislative framework as part of the crime fighting mechanism in Trinidad and Tobago. You know, Madam Speaker, Madam President, we are all aware, whether we like it or not, we live in a society where we are surrounded by a lot of criminal activities and a lot of white-collar criminal activities. I just read on the newspaper recently in the Trinidad Guardian of April the 6th, 2017, a $75,000 bail for a lawyer on fraud charges. The Newsday of the 22nd of February 2018, 27 charges for money laundering. This article details that since the setting up of the FIU in 2001, there were 27 persons have been charged with money laundering offenses. Again, not enough based on the amount of money that is outside there, but it is taking us somewhere, and we are surrounded by activities that we all need to start to fix. The Caribbean Financial Task Force, I mean, there's a particular report here, and if you read this particular report in pages 22 to 25, again, you are seeing where in there they have identified white-collar crime activities that they have identified here among us in Trinidad and Tobago. If you just look at what Senator Ramdeen went through, and we looked at the Financial Institutions Unit Act, or the report, and we saw $22 billion in suspicious transactions. That is the type of money and that is the type of environment under which we are presently being surrounded by. And therefore, this bill, one of the things that was very important in this particular bill was the whole idea of increasing the penalties that are associated with money laundering. For example, the Office of Facilitating Money Laundering attracts now a fine of $25 million and imprisonment for 15 years. Where a public officer or persons employed by the state commits the offense of tipping off, the offense attracts a fine of $10 million and imprisonment for 10 years. Where a public officer or person employed by the state commits the offense of failure to disclose money to disclose money laundering, this offense attracts a fine of $500,000 and imprisonment for 5 years. So we are also increasing some of the amendments. Is yes, we recognize that that crime is around us, and we are also in this particular legislation also moving to increase the fines in those particular areas. Madam President, you know, at the end of the day, this bill is also critical to Trinidad and Tobago because, as I mentioned before, we want to create laws as a country, but we are also part of our global village, a financial global village. And therefore, we have to put on the forefront there are serious implications associated with us not complying with these regulations. And as far as possible, we therefore have to put them in place. We have heard before a lot of what could be said about if we don't comply. I mean, last time I sat in this house, there were lots of conversations about delisting, all right? And one of the implications of delisting, and a lot of the financial institutions complaining about their losing of their corresponding banking relationships. And that is key when you do not comply. You know, and sometimes for us in Trinidad, because we have large financial institutions, and some of them are getting even larger, we do not understand that implication and how real it is. So, but I could tell you, 45%, right, just as right in the Caribbean, based on the March 27, 2017 statistics from the Caribbean Association of Banks, 45% of the correspondent banks exited the market entirely. 45% of them exited the market entirely. The remaining correspondent banks withdrew their services from some countries, and some banks, resulting in 55% of the 41 members experienced complete or partial de-risking. That meant that in some cases, even with interventions and begging and pleading, people, and there are countries who are operating among our neighbors who do not have correspondent banking relationships, and which is a clear indication, which is a clear what could happen if you do not go along with some of these recommendations. And when you do not have correspondent banking relationships, you know, what is correspondent banking relationships? A lot of us think about our lives today, things about what we have gotten accustomed to, about our lives, about having a bank account. We all have to have a bank account. As much as we hate banks, whether we want to have a bank account or we want to have a bank account in the credit union, but we need to have one. It's part of what we need. Correspondent banking relationships is very simply a bank also needs to have a bank account. A bank needs a bank account, especially to facilitate trade. You need a bank account to facilitate you paying of bills and buying things, etc. A bank needs a bank account to facilitate international trade. Other than that, you're asking a bank to have euros, US dollars, Chinese money, right? All the types of currencies, and when people are going or have to pay for something, you hire a boat or a plane and you send it up to pay, right? And then you pay, and then it kind of sounds crazy, but that is the life that will happen if you do not have a bank have correspondent banking relationships. And therefore, the implications of that is very serious. So we need to put these things in place, one, so that we could preserve this whole idea of being part of the global financial system. Another implication, of course, if you are not, when our country continue to be blacklisted, blacklisting, like anything else, if I tell you you are blacklisted or somebody is blacklisted, people look at you with cocky eye, as the saying will go, all right? They look at you differently. We do that ourselves. And therefore, if we want to compete globally, we want to talk about diversification of the economy, we want to talk about people making investments in our country, and people have choices. Why will I want to make an investment in a country that is blacklisted when I could make one that isn't? It's as simple. I mean, we all believe God is a Trinity. Yes, I agree. And we have the finest place in the world. But people make those choices. And if doing business with you is a little bit more difficult, we have to do whatever it can within the confines of our being a country. But we have to try to facilitate business. So we can't talk in one hand about diversification and trying to attract foreign investment to our country. And when we talk about the things that are required to allow us to get there, we say, no, 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 we can't do that. We cannot have our cake and eat it too. And therefore, it is therefore important that we pass these legislations. I want to just sidetrack a little bit and also recognize, as we saw, and that's why we have to increase the laws, the penalties as regards to money laundering. Money laundering is something that is very dangerous to an economy. You know why? Because money laundering also, one of the side effects of money laundering is that it actually puts out of business legitimate businesses. So it creates in a society the legitimate businesses, the people who are trying to do the right thing. They themselves, and if you are working for a company that is trying to do the right thing, you could find yourself being out of business because of money laundering activities. And any society that allows bad people to survive and good people to go out of business, one day you will recognize that that gets to the core of our society, of what type of country we want to live in. And therefore, money laundering, for all of these other reasons, money laundering will lead to unemployment, and money laundering could also lead in the creation of a society under which we do not want to be part. So as we talk about fixing this country once and for all as legislators, we have to play our role by putting the required levels of legislation in place. And I agree that that is not going to be the do-all and end-all of what is required. What is required is a lot more. But we have to do our part. But we have to continue to push others to create the type of society. We all know if it is not measured, it is not done. If there are no consequences for your actions, then there is nothing that will happen. And if it is that the difference between reward and punishment, the time frame is so far apart, then those are the things that we operate in our public service, in our teaching service. And therefore, those are the things, the absence of those structures is what is causing the problems that we have as a country. So I stand to support this bill 100% because it moves us along the path. Like Senator Ramdeen, do I believe that this will solve the problem? No. Do I believe that this alone is what is required? No. There's a lot more that needs to be done, but it moves us along the path. And I look forward to the national debate when we could start to deal with the other things that we need to fix, the serious things that we need to fix, and how we could come together to be able to fix those problems, not for this generation, but for the generations to come and all of Trinidad and Tobago. Madam President, I thank you.
Senator Hosein.
Thank you very much, Madam President, for recognizing me and allowing me to join this debate on a bill, an act to amend the Proceeds of Crime Act, Chapter 1127, the Anti-Terrorism Act, Chapter 1207, and the Financial Intelligence Unit of Trinidad and Tobago Act, Chapter 7201. And Madam President, this is a very short bill, just being 4 clauses. But the importance of this bill is underscored by our present situation that Trinidad and Tobago find ourselves in. Because so far, all of the persons who have contributed to this bill, Madam President, would have looked at the FIU's 8th annual report for the period October 1st, 2016 to September 30th, 2017. And Madam President, the FIU would have found that there was $22 billion in suspected proceeds of criminal conduct over the last year. And that would have been due to 877 disclosures. So if we do the math, Madam President, this would work out to, on average, each transaction over $25 million. So this shows that the persons who are involved in the money laundering, persons who are involved in terrorist financing, suspicious activity reports, suspicious transaction reports, they are big fishes, Madam President. It's not the small man who is involved. Because if one transaction can cost almost over $25 million, and that is just the STRs and the SCRs that have been detected, what about those that have gone undetected, Madam President? And let us look also at how law enforcement has dealt with this. Because there were 176 money laundering charges laid against 7 individuals for $7.2 million. So one transaction, $25 million, 7 persons charged, $7.2 million only, a drop in the bucket, Madam President. And these charges were related to illegal gambling, fraud, larceny, and drug trafficking. So that is the situation in which Trinidad and Tobago finds ourselves in. So that we have a problem, we admit that we have a problem with respect to white-collar crime. Time and time again, we come to this Parliament to make the relevant amendments based on our international obligations so that we would not be on the grey list or the black list with respect to FATF and CFATF. But Madam President, the bill should not only be passed to satisfy these conditions, we must also address the root causes of the problems in terms of white-collar crime. Because at the end of the day, we must admit that the white-collar crime in Trinidad and Tobago is that which fuels the street crimes. Mm-hmm. And therefore, we must nip where the resources come from in order to deal with serious crimes in Trinidad and Tobago. And in criminology, Madam President, there's a theory of deterrence by Beccaria. And he would have stated that there are 3 elements of deterrence. One being severity, the second being certainty, and the third being celerity. So therefore, when we look at the bill, we see that there have been increased fines. So we satisfy one condition in terms of severity. We look at certainty. Madam President, Trinidad and Tobago, we are failing in terms of the certainty in terms of conviction of these offenses. And the third is celerity, which is really how quickly we deal with the prosecution and convictions of these matters. And this bill before us would not in any way attempt to address the problems of prosecution, but rather to satisfy our international obligations. I know last night the Attorney General, I may have got him a bit upset, and he may have criticized the manner in which I debate and how well I articulate the points. But Madam President, I want to say it's the best that I try my best. I took an oath of office in this Parliament. I try my best, Madam President, in order to advocate the issues. And I will not be swayed. I will not be dismayed by the comments made by the Attorney General, Madam President, and I will continue to do the best that I can do in this Parliament as a senator. So, Madam President, I want to start off directly in going to the clauses of the bill because I know it's the Christmas season. I do not wish to detain this upper house, this Senate, very long. I know certain of my colleagues opposite will want to go home and play with their grandchildren. So I also take you into consideration, Minister of Trade. And Madam President, let me start off with Clause 2 of the bill. And Clause 2 of the bill is an amendment to the Proceeds of Crime Act. And the Proceeds of Crime Act, the first amendment deals with the removal, or sorry, the amendment to the definition of the financial institution at Section 2 of the Act. And the amendment is to remove from the definition an insurance agent, in a nutshell. So an insurance agent will not be subject to the Proceeds of Crime Act under the definition of a financial institution. Now, the Attorney General gave the explanation in terms of the reason for this removal in terms of the cost factor with the $1 investment as opposed to that it will cost $5 for every dollar. Now, Madam President, while I accept that argument, and I also looked at some of the articles that dealt with this from FATF, which would have indicated that insurance agents would be low risk in the industry, I still believe that they pose a risk. And therefore, I don't fully support the Attorney General's argument with respect to the removal of the insurance agents from the definition of financial institutions. Now, when we look at the rest of the definition that was included, if you would allow me to read, that the words to be inserted are that an insurance agent would, an insurance company or broker would be involved in underwriting and placement of life insurance other than term life insurance and other investment-related insurance. So there's an exception created in the insurance industry for those that carry out term life insurance. Now, I had to go back to look at what FATF would have defined a financial institution as. And the definition given by FATF in their glossary states that a financial institution means any natural or legal person who conducts a business, one or more of the following activities or operations for or on behalf of a customer: underwriting and placement of life insurance and other investment-related insurance. So FATF did not create an exception for term life insurance. They actually included it. So I asked the Attorney General, why did we just borrow from the definition of the glossary of FATF? And also they indicated that the definition applies both to insurance undertakings and to insurance intermediaries, which are agents and brokers. So FATF does, in their glossary, apply to both agents and brokers. But in our case, the amendment removes agents. It keeps the brokers, but it removes agents. So I'm asking, if FATF has included in their definition insurance agents, I believe that we should probably follow suit.
Yeah.
Because we must look at some of the implications when we remove agents from the definition of a financial institution, because as the Attorney General would have indicated in the piloting, supervisory authority has the power to request from financial institutions records in terms of SARs and STRs. So now if some insurance agent probably is involved in some sort of activities contrary to the Proceeds of Crime Act, they may not be subject to those conditions under the regulatory and supervisory framework of the POCA Act. And those are the concerns I would like to raise with respect to Clause 2A of the Proceeds of Crime. But also, sorry, I just forgot this point, is that I looked at Canada, Madam President, And in Canada, a life insurance company, a broker, and an agent falls under the Proceeds of Crime, Money Laundering, and Terrorist Financing Act of Canada. And in that framework, there are certain obligations in which those agents, the brokers, and the companies have in order for compliance with respect to the Proceeds of Crime regulations. And it says that if you are a life insurance agent and employee of a life insurance company or broker, there's a responsibility of the life insurance agent company, except with respect to reporting suspicious transactions and terrorist property, which is applicable. So therefore, if there are any transactions with respect to terrorist financing or suspected terrorist financing or money laundering, they have an obligation to report that, Madam President. And they have to complete Know Your Clients forms to verify the identity of their clients for certain activities and transactions. They have certain reporting requirements in terms of terrorist property, again, large cash transactions, suspicious transactions, and these must be reported to a body known as the Financial Transactions and Reports Analysis Center of Canada. And these are very important regulatory framework that are being put in place for insurance agents, Madam President, because as I mentioned earlier, while there may be low risk in terms of money laundering, terrorist financing, it still poses a risk. And I don't think that because of financial considerations, they should be the ones escaping the framework under which we are going to now detect money laundering claims, offenses, and terrorist financing offenses. Now, I want to look at the other amendment, which is Clause 2B, with respect to the offense that is created of tipping off for persons in financial institutions. Now, Madam President, the section reads at 1A, a person commits an offense if he knows, which is okay, or suspects that a financial institution or listed business is reviewing information, and to determine whether to file or is otherwise in the process of filing a suspicious transaction report or suspicious activity report, and he discloses to any other person information or any other matter which is likely to prejudice the filing of the suspicious transaction report or suspicious activity report. So where a person contravenes this section, when you look at the fine that he's liable to on summary conviction, is to a fine of $5 million and to imprisonment of 5 years. And this is that if a person just suspects. Now, when I looked at the Proceeds of Crime Act at section I'll find a relevant section, but Madam President, the point is that I think the element of suspect is too low. It should be a bit higher in terms of that there must be a reasonable suspicion, or it's at section 55A, where a financial institution or listed business knows or has reasonable grounds to suspect that funds are being used for the purposes of a transaction, to which subsection 2 refers at the proceeds of criminal conduct. So I think it's too low, Madam President, for a person to be convicted of tipping off by just him suspecting. It should be reasonable grounds to suspect. We should raise the standard a bit because the fines here, Madam President, are extremely high. $5 million and to imprisonment for 5 years. So I think that the Attorney General, I asked whether or not we can look at changing or qualifying suspect. I know the other provisions, the other sections, the Attorney General may answer me that with respect to offenses of tipping off with police officers, the standard is suspect, and also with respect to failure to disclose knowledge or suspicion of money laundering offenses. The standards are also that of suspect. But I think the fines are very high in order to just convict a person on a bare suspicion, Madam President. The other issue I raised, or I would like to flag, is that of Clause 2G of the bill. And Clause 2G of the bill, what it does is removes from the supervisory authority jurisdiction the National Insurance Board established under the National Insurance Act and also the Unit Trust Corporation of Trinidad and Tobago. And I listened to the Attorney General, and he would have indicated that the NIB would have been removed, and also the Unit Trust in particular would have been removed because they would now be supervised under the Securities Exchange Commission. But, Madam President, let's look at what this amendment will do. At Section 55D of the Proceeds of Crime Act, let us examine the powers of the supervisory authority. The supervisory authority can first inspect any business transaction record or client information record kept by a financial institution. So now, Unit Trust, NIB, the supervisory authority does not have that power to inspect their transaction business record or client information. They don't have the jurisdiction anymore to determine whether a compliance program has been implemented, and also determine whether or not there is compliance with the Proceeds of Crime Act, any rules or regulations made under it. This causes cause for concern, Madam President, because recently we've heard, and it's been reported widely in the media, with respect to the $3 million scam in terms of the maternity benefits at the NIB, Madam President. So those are issues that I wish to flag with respect to the removal of the Unit Trust and the NIB from the jurisdiction of the supervisory authority. Now I want to move on to the other amendment, which deals with the establishment of the National Anti-Money Laundering Counter Financing of Terrorism Committee, the NAMLAC, as everyone has been calling it. And yes, the Attorney General was right when this is a cabinet committee that was established in March 2006. And the TOR, or the terms of reference, Madam President, at that time were for developing strategies to rectify deficiencies identified in the mutual evaluation reports, recommending policies on legislative and institutional reform, reviewing draft legislation concerning AML, anti-money laundering, and CFT countering financing of terrorism environment, and to engage and consult with stakeholders to strengthen TNT's AML and CFT regime. And Madam President, these are some of the mandates that are being given here in this bill that was originally given through the terms of reference by Cabinet in 2006. But there were further mandates now being given to the NAMLAC under this bill that were not present in the terms of reference. And that is collecting and compiling statistics with respect to anti-money laundering, counter-financing of terrorism, and proliferation financing. Now, recently we would have concluded the debate on the income tax amendment bill. And I know while this may be restricted to statistics, I don't want that the committee, because in that committee you have the BIR, you have the Commissioner of Police, you have the AG, DPP, FIU, Central Bank. I don't want it to be a situation where information is being shared freely amongst these bodies, because we must take note that in the income tax amendment, even the police has to apply for a court order in order to obtain someone's taxpayers' information. But I understand that it's restricted to that of statistical information. But I just want to put that point on the record in terms of my concern with regards to that additional mandate being given by the NAMLAC. Another concern I have is that whether or not these statistics that are compiled by the NAMLAC will be available to the public. And I think that is an important point, because it's very difficult for us to get information with regards to statistics in terms of prosecution and convictions of these crimes of money laundering and terrorist financing. Also, through you, Madam President, Attorney General, can you also give me some indication of whether or not these persons who sit on NAMLAC will be receiving additional remuneration for the services that they would be offering to the NAMLAC? Now, let me move on to the other issue that I have in the bill, which is Clause 3, the establishment of the Anti-Terrorism Unit. Now, the Anti-Terrorism Unit, the establishment of this is not a FATF recommendation. I have looked at the 2016 fourth round mutual evaluation report, and I have not seen that they have asked Trinidad and Tobago to establish an anti-terrorism unit. I saw that they would have given an indication with respect to the establishment or including the NAMLAC into law, into statute, but not the anti-terrorism unit. And under the Anti-Terrorism Act, Madam President, the Attorney General has very wide, very draconian powers under the Act. And under that Act, Madam President, the Attorney General can do listings of persons and deem them to be terrorist or terrorist entities. The Attorney General can, in fact, designate areas which are declared, not the Attorney General, the Minister of National Security, sorry, can declare geographical areas as terrorist zones. You have the Attorney General can file for the seizure of assets of persons who are deemed to be terrorists. Powers of search, proposing names to the United Nations Security Council. And these are very draconian detention monitoring orders, Madam President. And these are very draconian powers that can be exercised by the Attorney General. So I want to ask the Attorney General, what is the reason? Because I did not get a clear indication from him. What is the reason for the establishment of the Anti-Terrorism Unit? Because I looked and I went back to a debate on the central authority, the creation of the establishment of the central authority. And then Senator Gillian Lucky, which has an identical provision to what we are doing here, Madam President, in terms of the Attorney General delegating powers to public officers and legal officers. And in that debate, Senator Gillian Lucky, now Justice Lucky, would have indicated that the reason for the delegation of the powers under the Mutual Assistance in Criminal Matters Act was because the Attorney General's office is very busy. The Attorney General himself may not be able to conduct all of the matters under the Act. So I asked the Attorney General, is there a lack of resources? Is it, what is it in terms of what is the rationale? Because I did not get a clear rationale. I looked at your contribution in the other place in terms of the establishment of the Anti-Terrorism Unit. And then Senator Gillian Lucky made it very clear what is the reason for the delegation of the powers under the Mutual Assistance in Criminal Matters Act. And Madam President, I don't wish to bring you into this debate at all, but I looked at the Hansard also, and there was a debate on the Mutual Assistance in Criminal Matters Act in which Senator Christine Kangaloo would have made certain comments, and I think those comments are very pertinent to this debate because they are very vital and very important questions that I would like to ask the Attorney General based on the concerns raised by the Honorable Senator. And the Honorable Senator would have asked, in terms of public officers are defined in the Constitution, but legal officers are not defined. What are the terms and conditions of these legal officers? Are we dealing with legal officers who are on contract? Are we dealing with what really are the terms and conditions of these officers? Should there not be some degree of permanence in these legal officers who are now going to be delegated these functions? Are consultants going to be given the same powers by as the Attorney General? And it went on to say that, Madam President, that we will not want temporary officers to be exercising such draconian powers because there's an issue of confidentiality in terms of the transactions under the Anti-Terrorism Act. And we would not want unsuitable persons. We would want a degree of permanence, and we would not want someone on contract who will be attending to these matters. And Madam President, those matters are very pertinent to this current structure in terms of the creation of the Anti-Terrorism Unit. Because we must be certain that the public officers who are given these powers of delegation by the Attorney General, they should be well protected. They should have some level of experience and qualification in anti-terrorism, countering financing of terrorism, in listing applications, in delisting applications, so that you don't have Tom, Dick, and Harry being given this power of these draconian powers of the Attorney General under the Anti-Terrorism Act. And we can probably prescribe in this legislation, because that was all the way in 2001. We are now in 2018, 17 years later, Madam President. Can we then prescribe whether or not these persons should have some level of qualification in terms of 5 years legal training, 10 years legal training? They must have some experience in terms of prosecution, some experience in terms of dealing with anti-terrorism matters, in terms of dealing with proceeds of crime matters, because they both are related. We can't just be given these powers. And when we look at the public officers, those public officers are not legally trained, but they may be given powers of delegation by the Attorney General. And these are issues that I wish to place on the record, because they may be issues of concern that I think that the government should take into consideration. There's one point, Madam President, I also wish to raise with respect to the delegation of powers. In the United Kingdom, there's someone called the independent reviewer in the UK. Because in the UK, their powers under their anti-terrorism laws are also very draconian, very serious powers being exercised. And the independent reviewer, he will normally look at the prosecutions, he will look at the investigations, and also he would propose amendments to the legislation. And I wish this was one of the matters raised at the Joint Select Committee when we were deliberating on the Anti-Terrorism Bill of 2018. And those were considerations brought to us by the stakeholders, and I think it's relevant now, because if you are given persons outside of the Attorney General these wide powers, I think there must be some check and balance in terms of the exercise of these powers. Attorney General, with respect to the annual report, at the new 38D, there's a typographical error. I think it should be 38C, not 38D. That is the first point. And the second point is that when you look at the Anti-Terrorism Act 1207, at the very last section, there was a creation of a new section earlier this year, which is section 43. The minister shall cause to be prepared and laid in Parliament an annual report on the number of prosecutions, convictions, listed entities, and orders made pursuant to this act. Now, you're including here now a new annual report under section 38D, which should be 38C. Now, the first annual report, I believe that will be the Minister of National Security would be laying that report. Attorney General, would not it be wise that we also include in this section, amend 43, instead of including a new section here in terms of the creation of annual report? Or is it that can we not give the Minister of National Security or add to these powers here so that there will be one annual report instead of two annual reports being brought under the Anti-Terrorism Act, because there will be two reports, one by the AG and one by the Minister. Can we not consolidate all under one annual report for ease of consolidation and reference in terms of the accountability of the exercise of the powers under the legislation? There's one point with respect to NAMLAC, again, I would like to raise. And I looked at the Proceeds of Crime Act in Bermuda, and Bermuda did legislate a NAMLAC in their legislation. And one of the powers being given by NAMLAC is that the minister who is empowered to make regulations under the Proceeds of Crime Act, the NAMLAC will consult the minister before those regulations are made, so that you give some sort of authority towards the NAMLAC. In this case, the NAMLAC is just being set up for the purposes of advising on legislation. But when there's a statutory requirement to be consulted, I think that will add to the effectiveness. It will add to to the efficiency in terms of the type of legislation and regulations that are being drafted in order to regulate the offenses and behaviors under the Proceeds of Crime Act. There are some other issues I wish to raise with respect to the listing applications. I know the Attorney General would have made approximately 502 applications, and then there were delisting, so there are over there are over about it's 258 individuals and entities listed, 3 persons being Guyanese and 2 persons being Trinidadian, Kareem Ibrahim and Shane Crawford. Now, Madam President, what this exercise really is in terms of these listing applications would now be done by the Anti-Terrorism Unit, by the way. That most of these persons who are listed here are dead in terms of Shane Crawford. What really happens is that an application is the UN, the United Nations Security Council, under their relevant resolutions, will deem a person a terrorist or deem someone, a company, a terrorist entity. And that list will now be made available publicly. And what happens is that an application is made to the court, and the court will be the one to list that individual domestically in our local jurisdiction. And when a listing application is made, an order is also made for the seizure of that person's assets. So I'd just like to ask the Attorney General, how many assets have been seized by these listing applications? What is the value of those assets? And how many of those applications that were made domestically were made based on the investigations locally by the law enforcement officers of Trinidad and Tobago? So those are some matters I wish to raise with respect to the listing applications. And Madam President, this bill comes at a time where, again, the Attorney General tells us that we have a deadline, and we have always tried our best as an opposition to assist the government in terms of putting Trinidad and Tobago in the best place possible. But I just want to register my disappointment with respect to these deadlines. These are very important legislation that we have been passing, and time again we come at the 11th hour in order to pass these very important pieces of legislation. I want to ask if by some mechanism that the government can employ in terms of bringing these pieces of legislation earlier, Madam President, so that we can have better, we can have more efficient, we can have fulsome contributions with regards to the pieces of legislation being amended, Madam President. And before I close, I probably have 3 minutes before we go to tea. But before I close, Madam President, I will try to see if I can get extra tea for everyone today, being our last sitting for the year. But before I close, I would just like to wish everyone season greetings and a bright and prosperous 2019 ahead of us. Thank you very much, Madam President.
Honourable Senators, Senator Hosein is giving you 3 extra minutes for tea, so we will suspend and return at 5 p.m.